May I please the listing of a matter on the 19th after reopening my lot? Regarding suspension of an employee of an excise inspector. Suspension has not been reviewed after 3 months. So on the last April, notice was issued. Uh,
19th.
Yes, 19th. I'm so glad.
I'm praying for listing of a fresh motion on Friday.
Why?
My lord, this is a promotion to the post of process server in MACT. Now the results were declared. Now they are going to fill up the feeder post, my lord. So provided my case is allowed, that particular post won't be vacant. Hence the urgency. And they did it within the vacation itself, my lord. So I filed it on Monday.
You were promoted.
I was not promoted. The private respondent was promoted to the post of process server. So, my lord, I have challenged the selection process because they have clubbed on basis of seniority come merit. They have clubbed the entire grade 4 posts. Whereas the grade 4 posts were, all of them were recruited.
High Court
separately.
matter
Yes,
tomorrow.
my lord.
Tomorrow.
Okay.
Well, my lord, I beg matter for listing of the matter day after tomorrow, my lord.
Why?
My lord, petitioner was suspended, my lord, and his suspension was set aside by this honorable court, my lord. Now they have again suspended him on the same, in connection with same case, my lord.
Motion.
Motion, my lord.
Okay, day after.
Lordship, I beg to mention item number 41, Lordship.
What do you want?
We'll file our reply as soon as we receive our instruction, Lordship.
Huh?
We'll file our reply as soon as we receive our instruction.
You have for oil.
Yes, Lordship. 1 to 6.
How many weeks?
Uh,
Is an interim order?
No, Lordship. After view vacation, Lordship. After vacation, Lordship.
You have taken the permission from the other side?
Taken, Lordship.
Wait when the matter reaches.
Please, Your Lordship. My lord, I beg to mention item number 2. My lord, I may be allowed to flow with liberty to refile that.
Oh, no, what liberty?
One prayer I have not made, my lord, in this case.
We'll see when the matter reaches.
Wait. This cancellation will be listed for admission on 28th of January. Would be it?
No.
Any date, my lord.
2nd of February.
My lord, deeply alright.
For withdrawal item 47,
Transfer cancelled by the government.
Yes.
my lord. Transfer cancelled by the government. Transfer cancelled by the government. Reservation, yeah.
You want to withdraw?
Yes, ma'am.
So and so submits that he has instructions to withdraw the instant writ petition. Mr. Ibotako appears on behalf of the
Forest Department.
Forest Department. Taking into account the above, the instant writ petition stands closed on withdrawal. Interim order, if any, stands vacated.
I had the mention, my lord. I had the mention, my lord.
What? More mention?
My lord.
Mention is over. I've started the list. Yes, what is this?
It's still directed to the offend instruction.
Huh?
We were appended after the selection of the year 1990 on a different scale of pay.
And this has to be, notice has to be issued. Without a notice, how is it possible? Does he have a case?
They were regularized, Your Lordship, way back in 1997. And they want the benefits of the revision of pay to be given to them retrospectively from a prior date, from 1992.
What?
And they have filed the petition now.
No. Regularize the service from the initial date of appointment, that is in the year 1990, and further, and you were regularized in the year 1997. Then where is the question of you are approaching after such a long time?
It is not because of my lord, non-regularization, etc. My lord, since my lord 90, we have been given my lord, the scale. of
No,
pay.
but Mr. Saikia, the question is, in 1997 you were regularized.
But they say it is regularized, but the letter does not say it is another order that has been passed in the year 1990.
No, where is your order of regularization?
Fact, connects at that time. I have the copy. The copy has been sent.
Only obstacle is coming that since 90 to 97, they did not give me the annual increment. And therefore, they are not counting my past services. And for that matter, the 95, the pay commission recommendation, which was.
No, kindly come to page 65.
Is 65.
That, sir, although our services were regularized in the year 1997. Then, what case you have?
They are mere saying, my lord.
No. After, you cannot wake up after 29 years.
They are still in the service, my lord.
So what?
So can they-
We are not going to reopen this. You should have come then and then. No case.
My lord, can they see the-
Division bench will help you.
my
Let
lord,
me dismiss
can
it right
they
away.
see the, my lord, recommendation of the.
No.
Pay commission, my lord.
Nothing doing.
My lord, pay commission.
Pay commission, no commission, what commission may do it, all these things. 1997 was your regularization, now you want it back from 1990.
As per the regulation, but actually the basic grievance is, my lord.
Kindly come to page 65. What is your grievance? Paragraph 4.
Actually. But they termed it as a regularized, they have been saying the regularized, but actually their grievance is not on that.
So that means your petition is different from what is given in the representation. So therefore your petition is not based upon a representation, and the justice which you have sought for is different from what you are now seeking out here. It goes against the very principle of mandamus.
Can they
That
see
is,
the recommendation, which has been adopted, my lord?
no. Same thing you have mentioned everywhere. Hello, let us dismiss this petition.
But,
Heard Mr. P.J. Saikia, the learned senior counsel, assisted by so-and-so.
the recommendation for payment of the scale.
Mr. Saikia,
revised
first and
price.
foremost, 1997, you have woken up in the year 2026. That's it. Simple aspect regard. You have given your first representation in the year 2024.
No, it is 1994.
No. Your representation after
Yes.
1997, where is it?
Page 24, my lord.
No. In 1997, you have been regularized. Where is your recommendation thereafter? Representation. The first representation is Annexure G, page 62.
24 is the one, my lord, by which it has come. my lord.
Chalo. Heard Mr. P.J. Saikia, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioners. Mr. K.P. Pathak, the
Yes.
learned appears on behalf, is the learned standing counsel, APDCL, appears on behalf of the appears on behalf of the respondent numbers.
1, 3, 5, and 7, your lordship.
1, 3, and Ms. K. Fukon appears on behalf of respondent numbers. You see, full stop. The present petition has been filed by the petitioner seeking a writ in the nature of mandamus, thereby directing the respondent authorities to regularize the services of the petitioner from the initial date of appointment, that is in the year 1990, and further grant all service benefits as admissible under the rules, including annual increment and revision of pay as provided to other regular employees from the date of the initial appointment. Full stop. It is relevant to take note of that the petitioners herein were appointed sometime in the year 1990. Thereupon, it is an admitted fact that in the year 1997, the services of the petitioners were regularized, as would be apparent from the very representations which have been filed by the petitioner, enclosed as Annexure G, H, G and H to the writ petition. It is further seen that after the regularization in the year 1997, the petitioner approached the respondent authorities in the year 2024 and 2025 seeking that their regularization should have been with effect from the date of their initial appointment and not from the date on which they were regularized to the services or regularized to the services under the APDCL authorities, APDCL and AGCL authorities. Full stop. It is the opinion of this court that the petitioners have approached this court, have approached the respondent authorities, have approached this court after 28 years from the date of their regularization, seeking that their regularization should be given effect from their initial date of appointment. It is a classic case of delay and laches for which this court is not inclined to entertain the instant writ petition, for which accordingly the writ petition stands dismissed.
Item 2,
2 and 3, Dutani. Yes, what is it? You want to withdraw? Why?
One, there, I have many standard.
Which one? What is the liberty sought for?
With regard to refinement.
Why? Why? This court doesn't grant a liberty just for the sake of it.
The one prayer method I have not.
What prayer?
We have not challenged my lord 89/2024 notification, my lord.
Huh?
89/2024 notification, my lord. I have not challenged my lord.
Yes,
This is a case of what? Compassionate appointment. Let us dismiss it right away. What is the question about that?
he has not
Argue.
challenged the 89/24 Lordship. He has not challenged the order dated 89/24 Lordship. He has challenged the 1615 Lordship, which is superseded by 89/24
Then
Lordship.
argue. Argue.
Last order, my lord, 14/11/2025, my lord. 14/11, my lord.
Okay. What is your case? Let us speak.
Okay, my lord, next chart 6, page number 36. I say that we.
Meeting dated demand is spent in force in scope of the application. Okay, this is a case of a compassionate appointment. Now tell me when did you, who died? When?
2017, my lord.
Huh?
17.
2017. And
Like, my lord, the 29/5/2017.
then?
Then, my lord, the DLC rejected on 5/8/2017 due to lack of vacancy. Thereafter, my lord, I have challenged this resolution before this honorable court. This court, by the order dated, my lord, 10/8/2022.
I remanded the matter to the GLC for consideration. Thereafter, my lord, again my case has been rejected by the TLC latest in the year 2024, my lord.
Then,
Then, my lord, we have to find my lord, another case, my lord, which is the common judgment has been passed by this honorable court, my lord, 342 Abdul Qadir Bakshi.
what is that?
Abdul Qadir Bakshi, my lord, all the cases has been remanded back to the TLC or SLC for fresh consideration, my lord. Accordingly, my case has been considered and rejected due to lack of vacancy.
Then,
On 16/8/2020 or 25, madam. This is my case, madam.
so there are vacancies.
There are vacancies, madam.
Where?
Madam, the last page, madam. In my petition, madam, last page, page number 44, madam. This is the part of the minors, madam.
Hmm.
There are various vacancies in any other department, madam.
Where?
Madam, vacancy position under compassionate court, madam.
You are claiming your right on the basis of the 2015, because at that point of time, that notification was holding the field. Okay, now where is that notification?
Certificate of madam. Page number, 23, madam.
Now, what is this? Why should we consider as of August 2025? Your father died in the year 2017. In the year 2017, you applied. Then till 2019, were there any vacancies? Till 2019, were there any vacancies? Because you see, kindly come to page 27, the principle number 10.
My lord.
No case. Second dismissal of the day. You are 27, work hard, get a government job.
My lord,
You have been able to get a survive for the last 8 years. You will survive. Don't worry.
my lord, yeah, my lord,
No right.
principle 10, my lord.
Principle 10.
Principle 10, my lord. My lord, from the date of application, 2 years. 2 years means, my lord.
So therefore, you have to show me that in spite of there being a vacancy in the year 2019, they did not appoint you. Then only I can exercise my powers on the judicial review. There has to be some illegality, not on the basis of this, that in 2025 there are vacancies. There's a basic principle behind. This principle number 10 is again based upon principle number, yes, 9. All vacancies available against the quota of compassionate appointment must be filled up within a period of 6 months from the date of occurrence of the vacancy in accordance with the present directions. So it is in basis of that. There is no, it is not carry forward. If you are entitled as per this, it has to be within this period of 2 months, 2 years. That
But
is-
in the
Chalo.
concerned department, there is no.
Heard, Mr. We dismiss it right away. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. So-and-so who appears on behalf of the respondent. Numbers 1, 2, and 3.
I'm appearing for
1,
respondent
2,
two, Lordship.
1 and 2, and Mr. So-and-so appears for the respondent number 3. The petitioner herein is aggrieved by the inaction on the part of the respondent, is aggrieved by the actions on the part of the respondent authorities in rejecting the claim of the petitioner for compassionate appointment by the impugned resolution of the DLC Kachar dated 16/8/2025, and further has sought for a mandamus directing the respondents numbers 2 and 3 to place and consider the case of the petitioner again before the district level committee for compassionate appointment in the concerned department or any other department as per the OM dated 1/6/2015. Full stop. The brief facts which led to the filing of the instant writ petition is that the petitioner's father, late Samiruddin Chaudhary, was a grade 4 employee of the executive engineer in the office of the executive engineer PHE, Silchar Division number 1, Silchar Kachar. Unfortunately, he died on 3/3, he expired on 3/3/2017, leaving behind his widow and 3 sons, including the petitioner. The petitioner applied on 29/5/2017 for appointment, seeking appointment on compassionate grounds in terms with the office memorandum dated 1/6/2015. Full stop. It is seen that on various occasions, the petitioner's applications was duly considered and thereupon rejected. And the last of such rejection was on the basis of resolution dated 16/8/2025 in the minutes of the district level committee meeting on compassionate appointment. Full stop. It is under such circumstances the petitioner has approached this court. Full stop. It is relevant to take note of that the appointment on compassionate grounds is not a source of recruitment and is also an exception to the mandate of Article 16 of the Constitution. Full stop. It is further seen from the judgment of the Supreme Court in the case of State of West Bengal versus Debabrata so-and-so, reported in so-and-so, wherein the Supreme Court had categorically held that there can be no claim, there is no right to claim appointment on compassionate grounds. So paragraph number 32 and paragraph number 33 of the state judgment being relevant is reproduced herein under. In the instant case, it will be seen that the state have, by the office memorandum dated 1/6/2015, formulated a policy to grant compassionate to grant appointment on compassionate basis, on compassionate grounds. Solely for the purpose of Asani Debabrata এখন Debabrata Basu is only for the purpose of Asani solely for the purpose of Debabrata Tiwari, ji. The 2025 was judgment. This was delivered when? No, this is an old one. Solely for the purpose of taking solely for the purpose of providing immediate succor to such a family when the sole bread owner expires while in service. Full stop. Under such circumstances, comma, the policy of compassionate appointment being an exception to the provisions of Article 16 of the Constitution, the case of the petitioner has to come strictly within the ambit of the said policy. Full stop. It is seen from principle number 10, as mentioned in the office memorandum dated 1/6/2015, that if the application of an eligible candidate remains pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making of such application, would require no further consideration and must be understood to have spent their force. First of all, under such circumstances, now, in that view of the matter, as nothing has been brought out before this court, that there was illegality in rejection of the petitioner's application in the year within (28/5/2019). That is 2 years from the date of application filed by the petitioner. So this court finds no ground to interfere, no ground to interfere with the decision of the respondent authorities to reject the claim of the petitioner for appointment on compassionate grounds. So considering the above, this court finds the present case not a fit case for issuance of notice, and accordingly the writ petition stands dismissed. Yes, Mr. Usami.
Let's say after 30 years from return of the service, the department proceeding was completed and the punishment has been imposed without the pension permanently. And the petitioner has preferred appeal that it was not disposed of till date. And that is why the last occasion also was directed to take the instruction. By appeal was not disposed of.
I received instruction, my lord. As per my instruction, my lord.
What is your case? No, wait.
My
Will
case is
ask.
also-
I may not even ask you also. First, let Mr. Gusami submit what is his case.
My case is.
Why are we aggrieved?
Look, my case is, look, in 2012, 8/6/2012, I have been transferred to Disney as an SDPO Disney. That time, there was a borough movement, ethnic problems are there. And Lord, allegation was that I could not control the borrow movement. And that is why, Lord, I have been placed under suspension, and thereafter, Lord, the department proceeding has been initiated.
You have not challenged the appellate order?
I have challenged the appellate.
Where?
Appellate order has not been passed till date, Lord,
Not passed?
not passed.
You have filed an appeal?
Appellate is high.
Yes, my lord, the appeal is pending, my lord, because appeal is under consideration. And
Okay.
now they have, my lord, sent to the, my lord, the judicial department for opinion. And it will be.
This is the appeal?
I
Where is the
appeal.
appeal? Appeal is filed on 1/4/2025.
25.
Okay, we dispose it with a direction to dispose of the appeal within a period of 3 months from today. When the appeal is pending, why should we hear? Heard Mr. S.K. Goswami, the learned counsel appearing on behalf of the petitioner, and Mr. T.C. Sutia, the learned counsel who appears on behalf of the
1, 2, 3.
1, 2, 3, and
And 5.
no, 5 you can't appear.
He is.
4. Mr. P. Nayak appears for respond number 4 and 5. We don't see an AG nowadays. R.K. Talukdar, who is an AG counsel nowadays? Let him have the benefit of disposal in his hands without his appearance. Anybody know the name of an AG counsel? AE counsel, yeah, AG counsel. Accountant General? Okay. 1, 2, and 4. None appears on behalf of the respondent number 5 on call. Gustav. The present petition has been filed by the petitioner challenging the findings of the inquiry officer dated 26/12/2013, as well as the order of penalty so imposed upon the petitioner dated 7/1/2025. And the petitioner has further sought for a direction that the regular pension and other pensionary benefits be paid to the petitioner. Full stop. The materials on record reveal that the petitioner herein was appointed as in the cadre of Sub-Inspector UB by an appointment letter dated 14/2/1984. Full stop. The petitioner thereupon have been promoted from time to time. Where is the charge sheet?
Lord, with my page. Page 44.
Full stop. Full stop. While the petitioner was serving as subdivisional,
SDPO. SDPO business.
what is that? What is full form?
Subdivisional police officer.
Police officer, Bizni.
And he joined on 35/2022, 12. And he was placed under suspension.
It's okay. Well, while the petitioner was discharging his functions as a subdivisional police officer, Bizni, he was put under suspension by an order dated 27/7/2012. Full stop. Subsequently, he was reinstated by the government notification dated 7/10/2013 without prejudice to initiation of departmental proceedings. Full stop. A departmental proceedings was initiated by issuance of a memorandum of charge dated 28/10/2016. Full stop. The petitioner participated in the said memorandum of charge, participated in the said departmental proceedings. And the inquiry officer so appointed submitted an inquiry report.
No, Lordship. Earlier inquiry officer could not submit any report, nothing was produced. Here, the new inquiry officer has been appointed after April.
Submitted an inquiry report on 26/12/2023. On the basis of the said inquiry report, the petitioner on the basis of the said inquiry report, an order was passed on 7/1/2025, whereby penalty was imposed of withholding of pension permanently in terms with Rule 21 of the Assam Service Bracket Pension Rules 1969. The petitioner, being aggrieved, filed an appeal on 1/4/2025 in terms with Rule 16 of the Assam Service Bracket Discipline and Appeal Rules 1964. The said appeal have been the appellate authority, however, have not taken any decision in respect to the said appeal. In view of the delay in disposal of the said appeal, the petitioner who have in the meantime retired
12 years back. 12 years back retail. Before penalty.
in the meantime retired. The petitioner who have retired even prior to the inquiry report being submitted was compelled to file the present writ petition on 28/10/2025. Full stop. The record reveals that this court had sought for instructions by an order dated 26/11/2025 as regards the status of the appeal and to place the same before this court. Full stop. Today, Mr. T.C. Sutia, the learned additional senior government advocate, submitted that the appeal is still pending. Full stop. This court have heard the learned counsels appearing on behalf of the parties. Full stop. And have given an anxious consideration to the materials on record. Full stop. Taking into account that there is an appeal pending, this court would not like to comment on the merits of the appeal as well as the legality or illegality of the punishment so imposed upon the petitioner. However, the fact remains that the inquiry report, the departmental proceedings culminated post the petitioner's retirement. And the petitioner presently is a pensioner. Under such circumstances, it is of urgent necessity that the appellate authority is required to dispose of the appeal as expeditiously as possible. More so, taking into account that almost 8 months have already passed since the filing of the appeal. Considering the above, the instant writ petition therefore stands disposed of with the following observations and directions. The appellate authority, that is, who? Who is the appellate authority?
Governor of Assam.
Huh?
Governor of Assam.
Governor of Assam.
Appellate, he is not there. The appellate authority.
Put a commissioner check it, Governor of Assam.
In terms with Rule 16 of the Assam Discipline and Appeal Rules is directed to dispose of the appeal as expeditiously as possible and preferably within a period of 3 months from the date a certified copy is served upon the respondent number
1.
1 to the Commissioner and Secretary to the Government of Assam Home and Political Department. Number 2. This court have not decided anything on the merits, and it shall be absolutely within the jurisdiction and authority of the appellate authority to decide the appeal in accordance with law. Number 3. The petitioner is given the liberty to approach this court again if the decision in the appeal is not favorable to the petitioner.
Petitioner is now a physically handicapped person.
Huh?
Petitioner is now a physically handicapped person. His leg has been amputated.
I can't help you with that.
So in case of physically handicapped person, law, it should be disposed of immediately. That's it.
In 3 months. No problem.
So that is 3 months I have given. What is this?
Holding up 50% of the family pension.
The earlier
Son of
section
the
for
deceased
family
to the
pension
second
should
wife.
be the name of the month first wife of the month. Even though which was subsequent to the
Page 18 annexure 4 is the order.
Huh?
At page 18 annexure 4 is an order whereby the authorities have held up 50% of the family pension, which I am entitled to.
This pension is given under what provision?
Is a family pension level under APTCA. And the
50% of the family pension benefits paid to so and so first wife AR till her death of AR. Next 50% may be held up for the children of the second wife till their employment or attainment of 25 years, whichever is earlier. Then
the son of the second wife, Your Lordship. So I paid for this 50% of the family pension, Your Lordship. It was held up and not released to me, not disbursed to me.
why?
Lordship, what has happened here was initially a next of kin certificate was issued.
What was issued?
Initially, a next of kin certificate was issued to the first wife and her children. They had the name of the petitioner's mother and his name was absent. Then a second certificate was issued where only his mother's name and his name was there. Then a third certificate was issued where the first wife's name, her children and the petitioner's name was there. Then the first 2 certificates were cancelled. Then there were proceedings before the district commissioner. In the proceedings, the district commissioner held that as the petitioner's mother was the second wife, she is not entitled to be, she does not have any legal rights.
Who?
The petitioner's mother as the second wife.
Ah.
And so he cancelled the first two certificates. The first, he revived the first certificate, which was cancelled which was earlier cancelled, where the petitioner's name was not present. So now, because of that, there is a conundrum as to what.
Ah, you, Mr. Mukherjee, you should go to bench 4. Don't you think so?
If your
You
lordship
need
has
to
the
correct
order,
the-
page number 9.
You have a good case. No, there's no quarrel with that. Hindu?
Hindu.
Hindu.
The Lordship, holding up of the family pension, Your
Huh?
Lordship, 50% of the family pension, holding
No,
50%.
understood. This is an order which was passed in the year 2023. Now the question is out here, what is your age? You are
22.
Huh?
22 years. 22 years.
Now, if they are creating a problem that cancelling the list of next of kin, because next of kin is an important document.
Now the present next of kin the certificate that is with the authorities contains my name as well, Your Lordship.
Is it?
No, lordship will kindly have the order at page number 9 of the bunch, which I've handed. Page number 9 of the bunch of documents. So it only
Your
says that
name is Biki Bosumotari.
his name is Biki Bosumotari.
And who is Nirupama Bosumotari?
Second wife, my mother.
Your mother. She's alive?
Yes, she.
Okay. Then? But what do you say about that full, although it is in the case of the Mohammedan, but it is in respect to the pension code also, why the same principle should not be applied, wherein the first wife, if she receives the amount, they are now bifurcating, whether by their rules they can bifurcate is another aspect. If they, normally in the pension code, the amount is to be paid to a particular person. Only one is the beneficiary. The others, but that beneficiary, one is the person who did, but that beneficiary takes it as a trustee for the all other person claimants.
Yes.
Why the
Here,
same principle is not applied here?
here the deputy district magistrate has taken a commitment from the first wife. Your lordship has the second paragraph from the bottom, paragraph number 4
Of
the order of 22/9/2022,
page?
page 9 of the bunch of documents.
Yes.
Paragraph
This is the
number-
latest one.
Yes, there.
Seen all the relevant documents submitted by both parties, Sobita Basumati and Nirupama Basumati, voters I card so and so. During the years of the stated that she is the first wife of so and her marriage was solemn above. This was agreed upon by Nirupama Yeapar and he admitted that she was married to the late Narendra Basumati in the year 1990. And it implied that she was the first wife of Basumati. Section 17 of the Hindu marriage again marriage between Hindu Solomonites after the convention of Niyai. As per the of the Assam Civil Code, no government serving has living wives shall contract another marriage.
Taken right.
Therefore, Nirupaya, who claims to be the second wife, is not legally recognized as per the. Furthermore, Mesopotamia had reported that you to take care of Timothy Nirupama Basumati's sons and so on education and meaning. And of the certificate dated so and so should be. Mister, have you challenged this?
No, Lordship. 22/9/2022. Not challenged.
Without challenging, you withdraw this petition and challenge this, and then I'm still waiting with you. Because this order needs to be challenged. It is absolutely wrong, taking into account that you have a right over that. But I can't do anything here because this is not an order which will come before me.
Lordship, in that view of the matter, my limited prayer, Your Lordship, my presentation at Annexure 5, Your Lordship, which is long pending because it is held up already. And if it is not disbursed,
It cannot be done. They will now follow this. And do you mean to say that this court, after being shown this,
manage that as well, Your Lordship.
this one,
Yes, Your Lordship.
then why you will not challenge this?
After that, Your Lordship, they have held it up, Your Lordship.
Obviously. So why have you not challenged this? You are in the wrong forum. Go before Justice Mehdi. Bench 4. Not me. Bench 3. You first challenge this, then come. Liberty, after challenge, I give you the liberty to come again, come back. But first you challenge this. Because without the challenge here, you cannot. Because I think this is section 17 they are mentioning. I think should be section 16 if I am not wrong of the Hindu Marriage Act. Because it is the personal property of that particular person. And as such, a person who is even the second wife or third wife's son is entitled to. Because this pension is not a bounty of the state, but it is one which is earned by that particular person. So if that be so, I think it is not 17, I think it's 16 if I'm not wrong. I've not forgotten this. But if it is 16, then obviously you have a right on that. Unless the pension rule says something else.
Yes.
And if the pension rule says something else, then the question is different. Then, but you have to challenge this. Or dismiss.
I can challenge that as well, Your Lordship. I can challenge that as well, Your Lordship. I can withdraw and challenge.
But without that, nothing happens.
But my submission in another aspect of the matter, Your Lordship, since it is already held up, 50% is already held up, Your Lordship, by order dated 13/1/20.
But why? But tell me one thing.
If I-
No, one thing. This order was passed on 22/9/22.
Yes, Your Lordship.
Why you have issued the office order on 13/1?
I asked them about the specific reason. They could not give me a satisfactory answer regarding that. I asked them that why this order was issued after that.
So unless this order is not set aside,
Yes, I do not have any written instructions on that issue, Your Lordship.
then what should we do? If that be so, this order has not been set aside.
This order,
So you are bound by this.
this order,
50%.
if Your Lordship directs, then I, very well, Your Lordship. I have no difficulty.
Allow your petition then.
Because I asked them
We have
specifically
to
about
issue
this.
notice.
That's held up already.
I asked them specifically.
Oh, you have not made that Sabitra Bosumutari a party.
Microphone.
Why?
Because I have only challenged this office order, Your Lordship.
Which office order?
Holding up my 50% of my entitlement. 13/1/20. I'm not agreed with the first portion. Whereby Sabita Basumata.
Maybe held up.
Yes, Your Lordship. Only the holding up of it without disbursing it to me. Because pension is an immediate necessity.
Which means for you.
For me.
Why? Who are you?
I am a student, Your Lordship.
Huh?
My representation is detailed, Your Lordship. My studies are also hampered. Your Lordship.
So she's going to pay that.
That's not been taken care of. Your
So it's a civil suit. Go there.
regarding the other things, Your
Go
Lordship,
before a civil court. Fight it out.
once it was held up, Your Lordship, in my favor,
That day I got one matter after 22 years, the matter finished. Mr. A. Ganguly was there. After 22 years, the same thing.
the
The
requirement,
money was held up in Apex Bank.
the requirement of family.
No,
pension-
Apex Bank, the central bank.
The requirement of family pension will no longer be existent then, Your Lordship. I may be a working man by.
But you get the back wages, na? The amount
That may not
is
serve-
50% is kept there.
That may not serve my purpose, Your Lordship.
So I can't help
Urgent
you.
Necessity,
Hello, dismiss your petition.
Lordship. as
Or
it is
Mr. No. Mr. B.J. Mukherjee, the learned counsel appearing on behalf of the petitioner. Mr. K.P. Pathak appears on behalf of the APDCL authorities. The petitioner hearing is agreed by the office order dated 13/1/2023, whereby 50% of the pension which is payable to family pension have been held up. Whereas the remaining 50% have been given to Srimati Sobita Bosumutari, who is the first wife of late Ronendra Bosumutari. The record reveals that pursuant to filing of the instant writ petition on 14/11/2025, this court sought for instructions from the APDCL authorities as to under what circumstances the petitioners have been deprived from the deprived of the 50% of the family pension. Today, Mr. KP Pathak, the learned counsel appearing on behalf of the respondent APDCL, have produced a set of documents which are collectively kept on record and marked with the letter X. From a perusal of the said documents, it is seen that there were various next of kin certificates issued full stop. Taking into account that there were various next of kin certificates, a dispute arose between the first wife and the second wife of late Ronendra Bosumatari. And accordingly, and on the basis thereof, the additional district magistrate Kokrajhar had passed an order on 22/9/2022. In terms with the said order, it is mentioned that the next of kin certificate can only be issued in favor of Srimati Sabita Bosumatari, who is the first wife of late Ronendra Bosumatari, along with her son and daughter. This order however, have not been challenged by the petitioner, in spite of having due notice of it. On the other hand, the petitioner have only assailed the office order dated 13/1/2023, which is based upon the order dated 22/9/2022. It is the opinion of this court that without a challenge to the order dated 22/9/2022, the petitioner, the order dated without a challenge to the order dated 22/9/2022 and a nullification of the said order, the office order dated 13/1/2023 cannot be interfered with. Accordingly, this court does not find the present case to be a fit case for issuance of notice, for which the writ petition stands dismissed. Liberty, however, the dismissal of the instant writ petition, however, shall not prejudice the petitioner to assail the order dated 22/9/2022, and if in the circumstance the said order is interfered with, the petitioner would always have the liberty to approach this court, challenging the actions for non-payment of the 50% of the dues of the family pension to the petitioner. It acts on point. What is this? Motion, Advocate General appearing?
This is regarding a
Something
recruitment
must
of
be very
APP,
serious.
and
What is this?
executive.
Your challenge should not be issued for causing the setting aside the impugned selection list dated so and so. Selection list of what? Should not be issued directing the respondent to reconduct the selection strictly in accordance with the advertisement dated demand by adhering to the reservation policy of so and so. Okay, now what is it?
He is a physically handicapped person, Lordship. I have annexed my physically handicapped certificate at page 19, Lordship. Wherein it was mentioned that I am having 50% of disability. Lordship. This is an orthopedically disabled, Lordship. Thereafter, Lordship, an advertisement was issued at page 23, Lordship. Wherein, Lordship, total 26 posts for public prosecutor and total 88 posts for additional public prosecutors, along with 188 posts for assistant public prosecutor were advertised, Lordship. So Lordship, in the post of public prosecutor Lordship, out of 26 posts Lordship, one post was reserved for physically handicapped person Lordship. Your Lordship means the post reserved for PWBD 1. Thereafter, in the post of additional public prosecutor Lordship, there are 4 posts reserved Lordship for PWBD candidate Lordship. So accordingly Lordship, the petitioner is eligible Lordship. He applied and appeared in the interview Lordship for the post of public prosecutor as well as additional public prosecutor Lordship. And in the interview Lordship, he did well Lordship. But while the impeach selection was published Lordship, it is seen that Lordship, your Lordship may kindly see the select list at page 32 Lordship. That in public prosecutor Lordship, total 26 posts advertised and 26 were selected Lordship. And serial number 8 Lordship of the said list, Hira Devi, who shown to be a PWD candidate Lordship. So one person that was filled up Lordship. But while Lordship, the additional public prosecutor Lordship, there are total 88 posts Lordship advertised, and out of 88, 87 were selected. One post kept vacant Lordship, but there were 4 posts for PWD candidate Lordship. But here Lordship, in serial number 11 Lordship,
Dhira Devi is there.
that Dhira Devi, who was already selected in the public prosecutor, she was selected as additional public prosecutor. Only one candidate was selected Lordship. And
Out of
she-
4.
Out of 4 Lordship.
Oh.
And 88 posts were advertised, 87 shown to be selected Lordship.
Appointed.
Not appointed till date Lordship. So this is my case. That I being a Lordship, physically handicapped person Lordship, at least I require to get a room Lordship against the reserved vacancy.
Yes, Advocate General.
I'll obtain instructions, but the thing is that so far as public prosecutor is concerned, there is one post that has been filled up by a physically handicapped person. We have reserved posts of 4 numbers in the additional public prosecutors category. So I have to instruction why, because it is not that only that criteria will be applicable, but the merit will also have to be looked into. We have 3 scrutiny or 3 committees headed by 3 honorable retired High Court judges. So I'll have to get the instructions for that purpose. Because
So don't fill up one post.
no problem. 4 posts are vacant.
It's okay. Don't fill up the post because they, as of now, they cannot be.
In additional one post.
You cannot appoint in the post of assistant public prosecutor for total 88, na?
Total 88 Lordship.
88. You can only fill up 84.
87.
No, you can only fill up 84
Yes,
because 4 are there, public prosecutor.
Lordship.
So for PWD. So as of now, you go ahead with 84.
No, let us go up to
Because
87.
later on, again, another problem may come. You go ahead with 84 because you have kept reserve 4. Huh? Why I'm saying is you have reserve 4. How do you take care of it?
Now somebody will come in future to the court that Lordship will not look into. One has come, so Lordship is protected his interest. I fully agree to that part. If there are no other persons,
But can a post which is otherwise what happens?
it will
to the
always
post?
go to the general category. It will always, if we suppose in lot of recruitments or lot of medical college also, when there is no candidates in STH. See,
And
schedule-
STH is different because it's a vertical reservation.
I agree, Lordship. But if we do
But,
not
what
find a
about
proper
hori-
candidate,
This is a horizontal reservation.
it's a horizontal, Lordship.
The
So,
horizontal, just for example, if it is a woman, I'm saying, let us say, take the example of a woman. Now you have to have a woman quota. Now,
Lordship.
if you have a woman quota, can you just
that is why Lordship may protect one, no difficulty on that. Regarding the other 3, maybe there was no candidate. I have to take instructions. Maybe there is no candidate who applied in that category.
maybe. Okay, we protect him
Yes,
in respect to one candidate.
Lordship.
issue notice, making it returnable on how long?
2 weeks, Lordship.
Okay. On 16th of February, 2026. Mr. D. Nath accepts notice on behalf of the respondent numbers 1, 2, 3, and 4. Full stop. The petitioner herein is aggrieved by the actions on the part of the respondent authorities in not selecting the petitioner to the post of assistant public prosecutor, additional public prosecutor in the PW to Horu D capital category. The materials on record reveal that the petitioner is physically handicapped and a certificate in that regard have been issued on 30/10/1999 by the Office of the Department of Orthopedics, Guwahati Medical College, Guwahati. An advertisement was issued on 2/1/2024 for filling up of 26 posts of public prosecutor, 88 posts of additional public prosecutor, and 185 posts of assistant public prosecutor. Footstep. It is relevant to take note of that for the purpose of, in respect to the 26 posts of public prosecutor, one post is reserved for PWBD. What is B? Full form of B? Persons with
With disabilities.
Huh?
With disabilities.
With benchmark.
Benchmark.
Benchmark disability. One post was reserved for PWBD. And in respect to additional public prosecutor, 4 posts were reserved for persons with BD. Bracketote agote likhi dibo, persons with benchmark disability. The advertisement further reveals that for persons with BD, there are to be considered eligible must possess benchmark disability and must produce necessary certificate issued by the competent authority and may be subject to further assessment. Next. The petitioner applied for the post of applied for both the public prosecutor, for the post of public prosecutor, as well as for additional public prosecutor. In the select list which was published, one person was selected, namely Dhira Devi, Srimati Dhira Devi, was selected in the category of PWD in the post of public prosecutor. However, "87 persons were selected for the post of additional public prosecutor. But no one was selected from the PWD category, wherein the petitioner also had applied. It is under such circumstances the petitioner being aggrieved. 87 persons have been selected out of 88 posts in the additional public prosecutor, wherein Srimati Dhira Devi also features at serial number 11 of the said select list. The learned counsel appearing on behalf of the petitioner submitted that the petitioner's case was not at all considered, in spite of the fact that the petitioner was a person with disability, which violates the mandate of the Persons with Disabilities Act, the mandate of the Rights of Persons with Disabilities Act 2016. And it is under such circumstances the present petition has been filed. This court have duly taken note of the select list insofar as the public prosecutor is concerned, as well as also insofar as the post of additional public prosecutor is concerned. In both the select lists, Srimati Dhira Devi have been selected in the PWD category. Obviously, the said Srimati Dhira Devi cannot be appointed both as a public prosecutor as well as the additional public prosecutor. And as such, in one of the two select lists, wherein, as such, in respect to both the posts, that is the post of public prosecutor as well as the additional public prosecutor wherein the petitioner had duly applied, there would be a vacancy in the circumstance Srimati Dhira Devi elects to accept the public prosecutor post or the additional public prosecutor post, as the case may be. It is also noticed that in the category of additional public prosecutor, there are 84 posts which are reserved for public persons with disability. Under such circumstances, the respondents herein are directed to file an affidavit on or before 9th of February 2026 as to why the petitioner's case had not been considered for the post of public prosecutor or additional public prosecutor in the category of PWBD. This court further observes that observes and directs that one post in the category of additional public prosecutor should not be filled up out of the 88 posts advertised till the next date.
In the advertisement, we have said that if a person is selected for two categories, within 7 days of the publication of the list, they have to inform that which post she or he would select. That is in page 39.
It's okay.
That's
So that is this. So I have mentioned it where it is
Yes.
not mentioned where they will be.
Deeply applies.
We are filing our affidavit today, madam. Yes, I will copy.
What's your case?
That the Petitioner. Page 25. It's 25 the implement of the.
Where is the order?
Page 25.
Page?
25 and accept the.
The period is over.
Yes, ma'am.
Then what do you
Still
mean?
they are not restoring my license.
You're not restored?
My lord, here, my lord, he has submitted a representation. In the affidavit, we have stated within 2 weeks, my lord, it will be considered. My lord, he is involved with, my lord, various criminal cases now. Search sheet has been submitted. He was behind the bars from February 25 to September 2025. All these corruption charges came.
But that again, you have to take
Yeah,
up
that is a
any
fresh
other
cause of
action.
action, my lord.
But you cannot, it has to be deemed that from
11/1/25, my lord.
no,
6
from 1st of July, the 12th of July, 6 months over on
11/1/25.
11/1. So from 12/1, you should be deemed to have a license in
Yes.
the register. We record that.
Yes.
Yes, ma'am. If any action is required, my lord, that we will take, my lord.
You
as
take
per the
action, but
law.
it will be deemed that he will be having a, yeah, and directing the Register Assam Council for Medicine registration to do the necessary, giving it effect from 12/1/2025.
Right.
Heard Mr. I.H. Soikia, the learned counsel for the petitioner, and Mr. B. Gogoi, the learned additional advocate general, who also appears on behalf of the respondent numbers 1 to 4. The petitioner herein is aggrieved by the inaction on the part of the register of the Assam, inaction on the part of the Assam Council of Medical Registration in not reinserting the name of the petitioner pursuant to the expiry of 6 months from the date of the order, 6 months from 6 months from the date from the order dated 12/7/2024. Full stop. It is the case of the petitioner herein that an order was passed on 12/7/2024, whereby the what is this kind? Assam Council of Medical Registration had decided to remove the name from the register of the petitioner for a period of 6 months as empowered by Section 23(1) of the Assam Medical Council Act 1999. Full stop. the petitioner. Thereupon, after the completion of the 6 months, which is on
11/1/25, madam.
12/1 on,
11/1/25.
which will be on 11/1, no? 11/1/2025, had requested the register of the Assam Council of Medical Registration for reinserting the name of the petitioner, reinstating the name of the petitioner, so that he is in a position to practice his profession. However, full stop. The verbal communications was followed by a representation dated 13/11/2025. However, as nothing was done, the petitioner has approached this court by filing the present writ petition. Full stop. It is seen that this court, by an order dated 1/12/2025, sought for instructions from the respondents as to why, in spite of the expiry of 6 months, the medical license have not been restored by entering the name or in the register of Assam Council for Medical Registration. In pursuance thereto, an affidavit in opposition has been filed, providing no reasons for doing so, for not reinstating the name of the petitioner. Under such circumstances, it is the opinion of this court that the actions on the part of the respondent authorities in not reinstating the name of the petitioner amounts to violation of Article 19(1)(g) of the Constitution, and as well as Article 21 of the Constitution. Accordingly, consequently, this court therefore disposes of the instant writ petition with the following observations and directions. First stop. This court declares that the petitioner's registration under the Assam Council of Medical Registration shall be deemed to be valid with effect from 12/1/2025. Number 2. The register Assam Council of Medical Registration shall forthwith and not later than 10 days from today reinstate the name of the petitioner in the register of the Assam Council of Medical Registration, giving it effect from 12/1/2025. With above the instant. With petition stand first.
Lordship, instruction not received, Lordship. Kindly fix the matter of the vacation, Lordship. I will let you. Regarding the genuineness of the disability certificate. Regarding the genuineness of the disability certificate, Lordship.
Genuineness of the
Disabled certificate, Lordship. Disabled certificate.
yes. What is your case?
Page 28, my lord. That is the certificate, my lord. I got the highest marks, but he has been appointed on the basis of this certificate, my lord.
When was she appointed?
Every note is not there, my lord. Select list is there.
Huh?
Selection list is there, my lord. Page-
Where?
Page 31.
Page?
31, my lord. 22/11/24.
What is your name?
Nazima Begum, my lord. I got 62%, my lord.
Hmm.
And
Who is number 1?
number 1 is serial number 4, my lord, decimal number 8. She got 41%, but.
She is PWD.
Yes, ma'am.
Then
PWD on the basis of certificate page 28, madam.
this was appointed in 2024.
24. ma'am.
Okay. You are also PWD.
No, ma'am.
Then
I got the certificate, can you see page 28, madam?
page?
Check 28, madam.
There is different handwriting, my lord, in the certificate, my lord, can you see, my lord?
How do you know?
Can you see the one, number 183, my lord? And
Let's see the advertisement.
and her name, my lord, can you see?
Advertisement.
Photo also, my lord. Photo also, advertisement, my lord, page 17, my lord.
Now, where's the advertisement?
Page 17, 17.
32 numbers of mini Anganwadi centers are promoted to the full status under so and therefore helpers and existing vacant numbers of so and so.
Page 18 is there, serial number 4, 3% post will be filled up from the physically disabled female candidates.
Ah.
That is there, my lord. My question, I'm questioning the certificate itself, my lord. I know her, my lord, she is a resident of.
You are questioning the certificate where? Here?
No, my case is that this.
No, Mr.
I already approached before the authority.
Where?
Representation can be seen, my lord. Application, my lord, page 32, my lord. My lord, details are filed like application before the district social welfare officer, my lord. RTI application also filed, my lord, but authority replied, my lord, kindly see page 43. Saying that this is personal information, so
Page?
page 43, my lord.
RTI, they did not give you the information. You didn't get any information. But who issues the certificate?
Health department, my lord. Health department.
Huh?
Health department, my lord. Respondent-
Social Welfare Department.
No,
Yes.
Certificate is issued by whom? Medical authority.
Yes, ma'am.
Now, have you approached the medical authority?
So this is medical authority, my lord.
Where?
This is page 43, my lord.
No, you are issuing, representing before the district social welfare officer.
This, letter, my lord, page, my lord, kindly see, my lord. Page 43, kindly see.
Page?
43. Reply, my lord.
Mr. Counsel, this is an RTI.
Yes, ma'am.
I'm asking you the simple question. Have you sought for cancellation of the disability certificate? Have you pointed out before the health department that look here, this is a fake certificate? Therefore, I'm asking, are you asking this court to decide as to whether this is a disability certificate or fake or not? How can I decide?
I got this certificate, my lord, from the social welfare department, my lord. Then I-
Understood. You are giving it to the social welfare department. You are saying that it is a fake. She is of sound health and all. But who has issued that certificate?
Health department.
Have you approached them?
I approached seeking, my lord, the photocopy of the original, my lord. That was not-
Uncle, you are asking under the RTI.
Yes, yes.
You are asking under the RTI. If the RTI does not give the information, you have a source of appeal. You can very well file an appeal. That is another aspect of the matter. I'm not on that.
Yes.
But the fact that how can this court decide whether it is a fake or wrong? What is your prayer out here? Have you sought for an investigation? Conduct an inquiry into the fake disability certificate of the respondent number 8. Who can conduct?
Respondent number 7, my lord. 7.
No. How can respondent number 7? Joint director.
Yes,
They
sir.
can do it.
Yes.
Okay. Who appears for the health department?
Last one is an APR, my lord.
Huh?
Name is there in the last order, my lord.
Okay, none appears. So we ask the health department person to be present. With the joint director of health service, we'll ask him to be present.
If,
Okay.
I will call Lordship.
Huh?
I will
You
call-
have no business.
No, my lord, this name not shown in the call list, my lord.
You have no business. Sir.
This name.
Name has been shown, then also health department is not representing. What to do?
Today not shown, my lord.
Huh?
Today in the call list, health department is not shown.
Shown.
Not shown. Not shown.
Who issues this disability certificate?
Yeah, that's the goal for that. Very good.
Consultant, my lord.
It will be eight goal for that. Civil hospital goal for that.
Yes, sir.
Hmm?
Page 29, Lordship. I think it is civil hospital, Gwalpara.
Can the Joint Director of Health Service inquire into? Can you inquire into?
Yes.
Okay. Issue notice making it returnable on 18th of February 2026. Mr. So-and-so, J.K. Gusami accepts notice on behalf of respondent number 1, 2, 3, 4, 5,
And 6, Lordship.
and 6. Miss D. Borana accepts notice on behalf of the respondent number 7. Extra copies of the writ petition be furnished during the course of the day. As regards the respondent number 8, steps be taken by way of registered speed post by tomorrow. In addition to that, steps be taken by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein have challenged the appointment of the selection and appointment of. Appointment is given or not?
Given.
Selection and appointment of the respondent number 8 to the post of
Anganwadi helper.
Anganwadi helper on the ground that the respondent number 8 had been selected as the has been selected as a PWD candidate. However, the disability certificate on the basis of which the respondent number 8 claimed rights as per the petitioner is a fake document. It is the further case of the petitioner that the petitioner tried to carry out necessary inquiry under the Right to Information Act 2005. However, no such information was divulged by the concerned respondent authorities. It is under such circumstances the petitioner has approached this court. The respondent number 7 is directed to carry out an inquiry in the meantime and apprise this court by way of an affidavit as to whether, as regards the genuineness of the disability certificate so issued to the respondent number 8, which is annexus 6 to the writ petition.
Yes, 7, 8.
Full stop. In addition to that, the other respondent authorities belonging to the child and woman or child or woman? What is that? Woman and Child Development Department shall also file the affidavit on or before 12th of February 2026.
8.
So the appointment of the respondent number 8 shall be subject to outcome of the writ petition.
This matter is regarding non-payment of debt cum gratuity.
What?
Non-payment of debt cum gratuity.
Debt cum gratuity.
Yes.
You have not got. Why have you not paid?
Lordship, today morning, Lordship, we have received oral instruction that the petitioner is the elder brother of this deceased person. And some Joy Ram Nursery was appointed as nominee by the deceased person.
By
So
the?
we want to, Lordship, some Joyram Nursery was appointed as nominee by the deceased, against which the petitioner approached, and the petitioner is the elder brother of deceased person.
Who is Joyram Nazari?
Joyram Nursery, Lordship, this is over phone we have received. Friday, Lordship, will file written affidavit, Lordship, on that instruction.
You were asked to obtain instructions as far back as on 8/12/2025.
Lordship,
Does it take so many days, months? It's
no, Lordship,
almost a
Friday.
month.
Friday, Lordship, will file.
Right? 10,000 cost.
No, Lordship.
Really?
Lordship, kindly peruse the records, Lordship. He is the elder brother. of
This
the deceased
10,000
person.
cost will be doing benefit to the other people,
Lordship,
the other lawyers who will be deprived of a matter being taken up on because of this matter going back on that date?
Kindly Lordship, allow first time Lordship.
Hmm?
In this matter, Lordship, I am praying for the filing affidavit for the first time, Lordship, in this matter. So Friday, Lordship will file.
Issue notice making it returnable on 27/1/2026. Ms. N.
And so do
Chaudhary accepts notice on behalf of the respondent numbers
3 and 4.
3 and 4. 3 and 4.
3 and 4.
Ms. So-and-so accepts notice on behalf of respondent number 1 and 2. The petitioner, who is the elder brother of one Ronema Nazari, since deceased, is aggrieved by the non-release of the gratuity, leave encashment and other benefits, and as such had approached this court by filing the present writ petition. It is noticed that by the order dated 8/12/2025, the respondents instructions were sought from the respondents. However, no instructions have been placed. Considering the above, list this matter again on, considering the above, this court grants a final opportunity to the respondents to bring on record their stand by filing the affidavits on or before 22nd of January 2026 by providing an advance copy to the counsel for the petitioner. On the next date, an attempt shall be made to dispose of the writ petition.
Obliged.
Madam, this order is also to you also. Everybody there, all the respondents.
Please, Your Lordship. Your Lordship, is on the leg at court number.
Who?
M1.
What do you argue?
Your Lordship.
You have 3 books with you. Argue. What do you want?
Time being, Lordship.
Huh?
Time being.
If you argue, I may issue a notice. If your senior argues, I may dismiss it. Which one do you want? Why the petitioner should not be appointed as an armed constable, considering his arms training at several trainings and also considering his long experience in various categories of home guards. Have you applied for that, Mr. Mahmood? Have you applied for any post?
No, I have not yet applied.
Then what is your case?
That liberty and lordship may kindly grant us. Because of my contemporary, another person from Ali, his name is here, lordship may kindly see. He has been appointed along with me. He was appointed. Then he was promoted. He was promoted, that means upgraded or adjusted as police constable. That lordship may kindly see page 7, para 6. After 6 lines, can you see? He may be also appointed as armed constable, but authority neither has appointed nor considered his prayer to appoint him as constable, though some similarly situated.
Where did you have the training?
Hello?
Where did you have the training? Burma? Training where?
Training he took.
Burma?
No.
Huh?
Then I would have been alpha.
You were an alpha, that is what you are saying. Didn't you say out here in this paragraph? That is why I asked you. You had the armed training. That petitioner begs to say the superintendent of law provided him along with other apprehending one hardcore alpha activist so and so, so and so.
Since
A
87, I
certificate
am
of
in
attending
the
third camp of
mainstream.
advanced training of Home Guard. Then
Whether we have killed.
he had rendered almost 28 years of dedicated service, and after completing of various services, he requested the authorities concerned, particularly the Subaya, either to appoint or absorb him as an armed constable, or considering his long he may also be appointed as an armed constable, but the authority neither has appointed nor considered it so and so. Yeah. Okay. Where is your representation?
My representation, my lord, though he has given that nothing is kept with him, but my prayer is limited, my lord. As I have all sorts of training, just like I'm constable. And my contemporary.
Mr. Mahmood, it would have been better if your junior was arguing, I would have issued that notice, but with you, I would not. I'm going to dismiss your petition.
No, some.
Now you can still take your chance.
as
If she is
my-
there, I would have issued notice, but with you, no. This is the case. She being just a budding lawyer, I may have issued a notice, but not at your instance.
Article 42 is violation is there.
Article 14 violation, I am willing to do vis-a-vis you and your junior.
Then I am going out, my lord. by-
Yes, yes. I am the issue notice returnable on 2nd of March 2026. Ms. So-and-so accepts notice on behalf of the respondent numbers 1 to 5. Extra copies of the petition be served during the course of by tomorrow. The case of the petitioner herein is that the petitioner was appointed as Home Guard and he had completed various advanced trainings. Full stop. However, persons who have been together, appointed together with the petitioner have been posted, have been appointed in the armed branch of in the rank of constable, whereas the petitioner have been deprived, and it is under such grievance the petitioner has approached this court. The respondents are directed to bring on record their stand by filing the affidavits on or before 25th of February 2026 as to why the petitioner's case has not been considered. Next date, your let your senior come, I'll dismiss it. Chalo. Where's Mr. Khan?
So in this case, the petitioner qualified in the medical examination. Thereafter, when the medical examination was done at page 68, it was
Unfit.
on the ground there is an infected wart on the left ear lobe.
Huh?
Wart, infected wart, W-A-R-T.
W-A?
R-T, page 58. It's like a mole.
Ah,
In Assamese, we call it kat asina.
ah,
So infected wart and left ear lobe.
ah,
Then a review examination was done
ah.
at page 59.
Hmm.
Before,
Unfit on account infigured due to infected wound left ear lobe. Yes, then
page 59, my lord, may kindly say infected wound present in left ear lobe. Dermatologist prescribe antibiotics since the outcome of the present treatment cannot be predicted, hence not acceptable. But after the medical examination was done, if my lord may kindly peruse paragraph 11, I have made a statement, categorical statement, that they took me to the ENT specialist. ENT specialist, that is at page 61.
Hmm.
It shows that the BCCM TM is intact, that is, eardrum is intact. That day, the ENT specialist asked me to ask the respondents to take me for a dermatologist opinion. Dermatologist report is at page 63. It
Huh?
says fit for job.
Page 50.
It is 63, madam, 63.
Who has given this?
This is page 63 is by the dermatologist. And page,
No, this is your person.
they took it.
No,
No, paragraph 11, I have made a statement, my lord.
you don't make these statements.
In the rejection, if my lord may kindly peruse at page 59. It says that infected bone present in the left ear local, dermatologist prescribed antibiotics. So after the first medical examination, they took me to the first to ENT, then to the dermatologist. And dermatologist prescribed antibiotics. It is not in the nature of permanent disability. And down below,
So you are saying that page 62 and 63 are opinions taken by them?
yes, they took me.
And how did you get the hold of this?
It's there, man. My lord, kindly peruse down below.
These are photos taken by mobile.
ENT specialist and dermatologist opinion attached. This was
Understood, but these are not those documents which
This
were
was-
given to you.
down below page 59. ENT specialist and dermatologist opinion attached.
Understood. Now, are you saying that these page 62 and 63 are these reports?
They took me to the dermatologist and the ENT. Yes, my lord. They took me. And they gave the dermatologist and the ENT specialist gave that report. And moreover, my lord, if my lord, on the last location, I submitted the guidelines. If it's not there, I can again furnish it, my lord. What is not a ground for rejection, my lord? Having a what is not a ground for rejection.
Where?
It's flag mark, my lord, page 101, internal page 7.
Page paragraph 20, clause 22.
Clause, clause 8,
Huh?
101. I have flag mark it, my lord.
Where?
101, clause 8, general grounds for rejection.
Then?
These are the grounds for rejection, my lord. Having a wart on the ear, it is not reflected in this grounds for rejection, my lord. And next page shows the minor acceptable defects. There at serial number S is any other slight defect which in the opinion of the recruiting medical officer will not interfere in the efficiency of candidates and soldier in future.
Oh.
So
There's no
it is not a
opinion.
ground for rejection, having a wart.
How am I going to look into this? Did you carry out any further investigation?
And the expert says that they were also asked to obtain instructions.
These documents cannot be trusted. Tell me whose document it is, page 62? Who is the person who signed it?
Nisa Bajoria.
Where do you get it?
I've made it. It was provided to me, my lord.
Page 62.
62. 62 is by doctor is Nisa Bajoria, MBBS, MS, ENT.
She has provided this.
And my lord, page 60 is written ENT specialist and dermatologist opinion attached.
So?
It is my copy, my lord. It is attached, my lord. On the left hand side, my lord.
No, your copy is there. We have consulted.
No, bad case. We dismiss it.
They were also directed to obtain instructions, my lord.
Who?
The-
Show me the medical opinion.
And that copy was attached, my lord. It is written on top on right side, my lord. Candidate's copy.
Mr. Roy, your officers, medical officers are what? MBBS, mayor?
MBBS.
Nothing more than that. It seems so. You have taken the opinion of these two persons
Lordship,
where they have said it is fit to do the job.
Lordship.
And your opinion out here says, kindly see paragraph 6.
Lordship.
That thereafter duly constituted board re-examined the petitioner keeping in view of the health and also clinic assessment. The review board, having been considered all aspects, arrived at the conclusion
Lordship.
that the infective wound earlobe needed treatment. And further, the course of treatment, whether his wound would heal or turn into chronic, could not be predicted. My goodness. Sorry, state of affairs.
Lordship.
Which way? Government of Home Affairs.
Lordship.
Huh?
Lordship.
They should also think about recruiting proper medical officers. And if these are the people who are treating our soldiers, then God save our soldiers. You should better not join there. One day you will die with these type of doctors. You withdraw then. Don't join. What do you say? Issue notice making it returnable on 16th of March 2026. Mr. S.S. Roy accepts notice on behalf of all the respondents. Extra copies of the petitions be served during the course of the day. The petitioner herein is aggrieved by the action on the part of the respondent authorities, more particularly the Review Medical Board, Review Medical Examination, nah?
Yes, madam.
Review Examination Board, dated 29/11/2025, wherein it was opined that the petitioner was unfit on the basis of the report of the ENT specialist and the dermatologist opinion. Full stop. Today, pursuant to directions issued by this court to obtain instructions, an instruction has been placed before this court by Mr. S.S. Roy, the learned counsel, appearing on behalf of the respondents, which is kept on record and marked with the letter X. From a perusal of the said instructions, it is seen that though the respondent authorities have based their opinion on the reports of the skin specialist as well as the dermatologist, but have not taken into consideration the contents of the said opinion, the opinions of the dermatologist, wherein it has been categorically mentioned that the petitioner was fit for job. Full stop. It is absolutely, it appears from the the instructions, more particularly at paragraph number 6 of the document kept on record and marked with the letter X, that merely on presumptions and assumptions, the Review Medical Examination Board have rejected have held that the petitioner was unfit. The said instruction therefore prima facie appears to be contrary to the provisions of law, and accordingly it is this court is of the opinion that this is a fit case for passing certain interim directions. Full stop. This court therefore directs that till the next date, one post in the category of
Constable. GD.
Constable,
GD.
Constable,
General duty.
Constable GD, pursuant to the advertisement issued dated 5/9/2024, should not be filled up till the next date. The respondents are directed to bring on record their stand by filing the affidavits. When did I fix it? 16th March. Affidavit on or before 6th of March 2026, liberty given to the petitioner thereupon to file reply on or before 13th of March 2026. An attempt shall be made to dispose of the writ petition on the next date. You do one thing. It's okay. We'll see next date.
Thank you, Lordship, my lord.
Yes, what is this?
My lord, I was appointed in the Northern Medical College and Hospital. I just, with your lordship's permission, I just want to draw your lordship's kind attention to page 4.
Issue a rule that as to why the representation dated so and so not been considered till date by What do you want, Mr. What's your name? Mr. Rahman, what do you want here?
My lord, subsequently, my lord, I have been, my lord, the difficulty is that my lord, no formal appointment letter was issued to me when I joined. But I just want to draw your lordship's kind attention to page 18, annex rate. Page 18, annex rate. Subject joining report, with your lordship's kind permission, just I am just reading out the relevant portion for lordship's kind convenience. Bhartal directions, date 25/4/2023. I have the honor to inform you that I have joined my duty as assistant accountant at Nagaon Medical College and Hospital, Nagaon, accordingly daily wages basis, 25/4.
Where is your representation?
My lord,
Where is your representation?
representation, my lord, I have submitted in the DME, my lord.
Where is it?
It is not here, but problem is this, my lord.
Mr. Rahman, you are asking this court to direct the respondents to consider the representation
My lord.
and you don't enclose the representation. What type of petition is this? Isn't this your prayer out there, paragraph number page 14? That why the representation dated 13/11/2025 not been considered till date, that a representation be considered by the respondent number 2. How do I grant you a relief in respect to those representation which is not there on record? Withdraw. File a proper one.
My lord. Absolutely.
Mr. S.S. Rahman, the learned counsel, Triple S. Rahman, the learned counsel, appearing on behalf of the petitioner, submits that he may be permitted to withdraw the writ petition with the liberty to refile by taking into account that there are formal defects. Accordingly, the writ petition stands closed. Liberty, however, granted to the petitioner to refile by enclosing the representations on the basis of which the petitioner claims that he is entitled to any relief.
12,
Arbora, where is Mr. Arbora? Yes. Instructions. What is this?
Page 49 is the
Medical test?
medical test.
What is this medical test?
He was rejected on account of hypertension.
Citing a impugn medical. Where is the opinion?
Actually, page 49.
Page 49. Hypertension BP 154/96. You want to become what? Constable?
Lordship.
Finished? No. First day 154/100. Second day 150/92. BP monitoring after admission shows fluctuation, hence declared unfit. Rightly so. Then what is this? Deformity. Now, before another person, National Health Mission, your BP comes down to 110/70. Then,
Lordship, the only issue here is that Lordship, page 55, Lordship will find.
what should I do? Ask the High Court doctor come here and then ask him to measure him?
Absolutely no.
Then?
Because at page 55.
Go there.
Fine.
You know.
Lordship, kindly see page 55 for a moment.
Page 55.
The guideline 7E, because there is a guideline issued by the Ministry of Home Affairs, they say that once a candidate is rejected due to hypertension, the doctor, concerned doctor has to give an opinion whether the rise in blood pressure was of transient in nature or not.
Following examples are cited for the guidance of Iman in a cardiac vascular where for candidate who has been rejected on the grounds of tachycardia should be admitted, hospitalized by the board before giving their final opinion regarding the candidate or otherwise. The hospitalization report should indicate whether the rise in blood pressure is of transient nature due to excitement, etc., or whether it is of X-ray and electrocardiogram of the heart. So these have not been done.
No.
No, Lordship, it is only in case of any doubt. Kindly come to page 55, paragraph D. Top.
For
Review
vascular disease like varicose veins, so and so. Huh? See?
D.
To rule out any E.
Page 55, D.
To rule out any eye surgery.
No.
The Review Medical Board may
Review Medical Board may obtain opinion of concerned specialist or super specialist of government medical college and hospital in case of any doubt. Therefore, in case of rejection in review medical examination, clinical findings should be corroborated with confirmatory test investigation opinion of specialist, super specialist of government hospital, medical college, government approved private medical centers, whichever and wherever applicable. Following examples are cited for guidance of review medical board. These are only examples. If there are any, in case of any doubt arises before the
No,
review medical board,
but madam, one has to look into it. That you see, you have, where is that
candidates.
page?
49.
You have held him that he is unfit on the ground of hypertension.
As per guideline.
You took it on one, yeah, but did you have a continued as per E? Have you looked into it?
Yes, Lordship, that is example, as for example, Lordship, this guideline. And if any doubt arises.
So are you submitting these examples have no value?
No, Lordship.
No, make your submission. We only,
No, if any doubt arises
that
before the
means
review.
as
medical-
Purva's submission is better than what is stated out there in the examples.
No, if any doubt arises before the review medical. board,
No,
Lordship,
there's a reason why. If a person has to appear in some form of some examination out there, his BP would be going high. So you are to therefore look
Therefore, he
into
was
it.
admitted for 3 days in before the 2 days before the at Composite Hospital BSF.
How do you know
Lordship.
that?
Yes, here it is.
Show me that.
Here it is in.
In fact, the rejection itself reflects that he was admitted for 2 days because it says that first day and second day.
No, maybe today he may call you, tomorrow he may call you. Isn't that possible? And that the detail was carried out by the medical officers strictly in accordance with the revised to Iman. The instance was that the in the city of Iman for the opinion which was one of the board was taken. That mention here that is the parasites and Paravan Iman is one of Iman. Hence the medical review in Grade 2 to conclusion. Hypertension 96. Hypertension metabolic monitoring slowly ECG. So we dismiss his case. You should dismiss his case, that means. Okay. We dismiss.
Lordship,
No case.
May kindly see.
No.
Lordship, their own guidelines first says that these are the examinations which have to be carried out.
They have carried out.
Lordship, But the medical report has to be, must be given an opinion whether the rise in the blood pressure is of transient nature or not. Once that is not given,
You were admitted to a ward.
Lordship. I
Your
understand,
echo was done.
Lordship,
Echo
Lordship.
done. ECG done.
No,
That
I
is-
understand, but whether it is transient or not, that has to be there, Lordship. Because at 56, guideline number 8 says that a candidature should not be rejected only on clinical findings. And therefore, they have to give an opinion that your Lordship can see. Rejection merely on clinical findings is to be avoided.
This person tested you twice or thrice.
Twice.
Then, no, your echo was taken.
No, I understood. Those are the clinical findings.
Then,
But an opinion has to be given, and that is why guideline number 8 is also provided.
opinion from whom?
Opinion by the doctors who have examined the petitioner,
So the review medical board, doesn't it consist of doctors?
but they have not given the opinion. That
They
whether
have
it
given
is-
that opinion it is unfit.
No, only that much only.
What else do you require?
Whether it is transient or not, Lordship, that is required.
Whether it is?
Whether the rise in the blood pressure is of transient nature or not, or whether it is because of any disease.
No, that is why the echo was done.
Lordship, that is the only the clinical finding. Echocardiography is a clinical.
The division bench will help you. This court is not going to help these people.
Because once they do not follow their own guideline,
Okay, I'm not satisfied with your case, but I'll issue notice making it returnable after 6 months. No stay.
Lordship.
In the meantime, you go ahead. Don't appoint him. This will become an infructuous petition by that time.
I leave it to you, Lordship.
Huh? No. I don't feel like issuing notice again this.
Because the ECG was carried out at Narayana Hospital, once the ECG was carried out at Narayana Hospital, an opinion has to be taken from the doctors of the Narayana Hospital. Because they have referred the petitioner to Narayana Hospital. And that is what their guideline 6D says.
Where does it say?
Review medical board may obtain opinion of concerned specialist or super specialist of government medical college and hospital in case of any doubt.
There was a admission in the ward, BP monitoring 2 hourly. ECG done. That this court can't look into all these things.
Let them file an affidavit, Lordship. I will try to make my case better then.
Oh. Anyways, you file your affidavit. Issue notice making it returnable on 24/2026. Ms. So-and-so accepts notice on behalf of the respondent numbers 1 to 5. Extra copies of the writ petition be served upon them by tomorrow. The case of the petitioner herein is that the petitioner herein have challenged the opinion rendered by the Review Medical Examination Board, wherein the petitioner has been declared to be unfit on the ground that the BP monitoring after admission shows hypertension. Full stop. The petitioner submits the case, the learned counsel of the petitioner submits that the decision so taken by the Review Medical Board is not in consonance with the guidelines dated 31/5/2021 issued by the Ministry of Home Affairs / Griha Mantralaya, Police Desk Roman II Division. Full stop. It is seen that this court, by an order dated 17/12/2025, issued notice, is sought for instructions In pursuance to that, comma, instructions have been produced by Miss so-and-so, the learned counsel appearing on behalf of the respondents as Burua. From a perusal of the said instructions, it prima facie appears that the respondents have carried out the necessary investigation which are required for forming that opinion as to whether the petitioner was fit or unfit. Be that as it may, comma, it is the opinion of this court that such instructions be brought on record by filing an affidavit so that the petitioner is in a position to file any rejoinder thereagainst. Accordingly, let the affidavit be filed on or before 10th of April 2026. It is made clear that this court is not convinced to pass any interim directions, and as such, there is no bar. The pendency of the instant writ petition shall not be a bar for filling up the posts.
Rigs and hardened allowances during the period 2019 to 2023 while they were serving in 128 battalion. Now the respondent authorities has initiated process to recover the same height implement order dated.
Are you working?
Yes,
What do you do?
some liquidation pending.
You got what is this R&H allowance? What is that?
Rigs and hardship allowances.
High hardship allowance.
Yes.
Now they want to recover. Why? Because later on they came to learn that that is not an area for risk and hardship.
But as per office memorandum dated 22/7/2019 lordship, the area was covered.
Huh?
Next at 3 lordship,
Area where?
covered lordship. Next at 3 place 14 lordship.
Annexure 3.
Yes.
Yeah, I passed some order to that effect some years earlier.
Petitioner pending lordship with issue.
Huh?
Some petitions are pending lordship.
Mr. Doctor, I passed some orders earlier, no? Once upon a time when I was taking up those long.
Lordship and excess 6 and 7 lordship. And one disposal order lordship and excess 5. Relating the same issue.
But there is a stay
Yes.
given by others.
Yes.
Chalo. Issue notice making it returnable on 11th of May 2026. Mr. A.K. Datta accepts notice on behalf of the respondent numbers 1 to 6. Extra copies of the writ petition be served by tomorrow. The petitioners herein are aggrieved by the action on the part on the basis of the communication dated 22/5/2025 issued by the respondent number 4, whereby steps have been taken to make recovery of the R risk and hardship allowances which have already been paid to the petitioner. It is the case of the petitioner that the area wherein the petitioner performed the duties for which the risk and hardship allowance were paid falls within the area wherein the said allowance is permissible. And as such, the action on the part of the respondents to make recovery is completely unwarranted. The learned counsel appearing on behalf of the petitioner further submits it is also inequitable on the part of the respondents to make such a recovery. When was that period where you got it?
Yeah.
2009.
19th to January 2023 lordship.
After the passage of so many years, the The respondents are directed to bring on record their stand by filing their affidavits on or before 30th of April 2026. Liberty given to the petitioner to file reply, if any, on or before 8th of May 2026. This court further taking into account the submissions so made as well as the materials on record, and further that similar or certain interim directions have been passed by the learned coordinate benches of this court, directs that the respondent authorities shall not take any coercive action against the petitioners on the basis of the communication dated 22/5/2025 till the next date. Right.
Lordship, the petitioner had challenged this transfer order, Lordship, and he had obtained a stay, Lordship, on page 11, Lordship, by order dated 5/12/25, Lordship. Thereafter, Lordship, the matter came up on 10/12/25.
Huh?
The matter came up on 10/12/25, Lordship, page 50,
There was a initial order passed on
on 5/12/25.
25.
page
Then
11.
shall not be given effect to.
Yes,
Then,
page 15, your Lordship.
then this order was of 5/12, you intimated on 9/12,
Lordship.
and this was intimated. Then what happened?
Then, Lordship, the matter came up on 10/12/25.
Prisoner before he is agreed by the impugned transfer order whereby he was transferred to the new post of posting. On when the respondent was permitted to obtain it. Today, when the matter is called, although complaint by the BDO has been placed before it, however, time is sought by the so and so to complete instructions with regard to the steps taken pursuant to it. List the matter on so and so interim order, if any, in pursuance to the employment of the transfer order in respect to the accredited presently serving as so and so, and shall not be given effect to until further orders. Okay, then.
Lordship, here in page 17, the order has been passed, Lordship, where he has been from his present place of posting, he has been attached to the head office, Lordship.
Huh?
He has been attached to the head office, Lordship.
Attached to the?
Head office, Lordship.
Ah.
And also, Lordship, if Your Lordship may kindly see copy 2, serial number 2 on page 17, Lordship. The chief executive officer so and so, for favor of so and so, he is directed not to allot any official work to the said employee until the court proceeding. Lordship, this is amounting to punishment, Lordship. Not
So?
allotting any, Lordship.
What is the contempt?
Firstly, Lordship, transferring from present.
We do one thing, we dismiss this petition, that petition together on 9/1/2006, the other matter is there. List this contempt application along with WPC number 6883/2025 on 9/1/2026. Yes,
I want to offer myself, my lord, apologies, my lord. The annexure was there, my lord. Application was drawn. Item number 11.
what is that?
Your worship, sought.
The
for
representation is there.
Yes,
Item number 11 too, we'll again take it up.
Apology, my lord.
Now, first of all, you have to read the brief. Okay, let me dismiss it in the absence of the respondent. Item 11 to the. What is your case now? Tell me.
Subsequently, I oblige, my lord.
Annexure, page?
Last page, my lord, annexure Q. Page number 45, my
With
lord.
due respect, I
And that
propose
is
to write the
representation that I
supplication
filed
with
on
reference to
13th,
the
11th,
to request your
2025.
kind intervention to solicit your guidance.
And I was continuing, I am still have been continuing my duty as an accounts assistant in the Nogam Medical College and Hospital for the last 2.5 years. Now my present principal, my lord.
Hello. Okay, we dismiss it on this ground only. Don't say we don't require the other side. Heard Mr. Triple S Rahman, the learned counsel.
A. Rahman, my triple S Rahman is the
Triple, you are one shot.
A. Rahman, my lord.
SSA.
Twin brother.
Okay, twin brother.
Confused.
Okay. Heard SSA Rahman. A.
A. Rahman.
Okay, A Rahman. But here it has been mentioned as here, Triple S Rahman on top. So I thought that, okay, you are SSA. SSA Rahman, the learned counsel appearing on behalf of the petitioner. Who is the other side? Health, na?
Health department.
Okay, Mr. Who wants to be a health counsel? Okay, Ms. D. Bora appears on behalf of the Health and Family Welfare Department of the Government of Assam, and Ms. S. Burwa appears for the respondent number 1. Full stop. The petitioner herein have filed the instant with petition being aggrieved at the inaction on the part of the respondent authorities in not considering the representation dated 13/11/2025 submitted by the petitioner to the Director of Medical Education, Assam. Full stop. This court have duly perused the materials on record. And from a perusal of the materials on record, it is seen that only on 25/4/2023, it is seen as claimed by the petitioner that on 25/4/2023, the petitioner was appointed to join on a daily wage basis. Full stop. Thereupon,
And
it is also seen that certain experience certificates have been issued that the petitioner has been rendering service as
accounts
a-
assistant.
rendering service in the accounts branch on daily wage basis in the Nagaon Medical College. Full stop. The petitioner thereupon submitted a representation on 13/11/2025 that the petitioner's case should be regularized, petitioner services be regularized and thereby brought within the fold of the services of the state. Full stop. It is the opinion of this court that the petitioner herein, the representation so submitted by the petitioner cannot, no, it is the opinion of this court that what the petitioner seeks by way of the present petition, by way of the representation, is to give the petitioner, is that the petitioner be brought within the services of the state, which on the face of it is in violation to the principles of violation of Article 14 and 16 of the Constitution. More so, when the petitioner have not been able to show that there is any policy of the state to regularize the employees in the medical department. So consequently, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed.
There is one point left of my lord. The public streets, my lord, the annexes, my lord, please start for. I'm not on that, my lord. I'm not on that, my lord. Because the principal, the present principal has asked me to go out, my lord, leave this job and join the other job. That is why my grievance was also on that, my lord. If your lordship can kindly come to page 34, answer say, I sent a WhatsApp message to the principal who has asked me to, if you are not doing this duty, accounts of assistant. you can do
Mr. Rahman, first of all, you have to understand the manner in which you have been appointed. It in fact dazzles this court as to how it can be. Appointment order, you say that I have joined, and some principal or whoever puts a handwriting out here, allow him to join. This is your appointment order.
No appointment that was given to me.
No, obviously, this is what by which you joined. There's a certificate also being given by the principal out here that he has been working from 25/4/2023 till date. Your representation is kindly regularize my service after 2 years.
No, man, I am not for that, man.
Are you not asking for regularization as per 13/11?
Only my lord. That is there, my lord. One part of the pay is there. But the condition is, my lord, I have been working the others 78% is working also there, my lord. Only, my lord, the principal has verbally asked me to go out and seek the job in the other sectors, my lord.
Other?
Other sectors. Other private sectors, my lord.
Go there.
Other sectors, my lord. Only because, my lord, I am relying on the Uma Bharati's case, my lord. She is very well.
Uma Devi.
Uma Devi's case, my lord.
Uma Devi, what does it say?
my lord, as because, my lord, if I had put sent out, my lord, there's some principles is to be followed, my lord. Article 311.
No, how will 311 be applicable to a person who has not, doesn't even have an appointment letter?
I'd be happy, your lordship kindly is to notice, my lord. that-
No, 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 no.
Violate that.
Mr. Roman, getting a notice is a good thing, is a very difficult thing, and getting a stay is even more difficult.
This is your WhatsApp messages, my lord.
Very lucky you are getting WhatsApp messages. Go to the civil court. Anyways, it's the end of the game. First, I allowed you to withdraw or simply withdraw it.
My lord, then I am trying.
Simple.
My lord, trying.
Simple withdrawal. I miss that he will like to withdraw.
Yes,
at your
my lord.
place.
Obliged. I live. I think mention one, item number 51, supplementary, there is a motion matter, but the prior duration is last item.
Urgent.
It's that yesterday the lordship has permitted it. It is relating to recruitment, lordship, and last date is 9th. Obliged.
51. Yes, what is your case?
My case is that lordship, I'm BSc, Royal BSc, lordship, and I have completed 2 years apprenticeship in the Guwahati refinery in boiler attendant, lordship. Now they have plotted an advertisement, lordship. Earlier, lordship, under apprenticeship act, lordship, I get some benefits, lordship. First is there is a preference for apprenticeship. Secondly, lordship, there is a phase relaxation. That two benefits has been now in the advertisement, it is not incorporated. Lordship. So I will be averaged by 10 months, 10, almost 11 months, lordship.
Huh?
11 months. Otherwise, I will be averaged for 11 months, lordship.
No, tell me one thing. This notification was issued as far back as on 24/9/2022.
Yes, lordship.
What are you challenging here?
Lordship, I am challenging that under the apprenticeship act, lordship. I have to get some benefits, and those benefits has to be incorporated in the advertisement, lordship. Earlier, in all the advertisement, lordship, oil and and the establishment had incorporated those benefits, lordship. Now they have omitted these conditions, lordship. There are statutory benefits, in fact, under the apprenticeship act. But you will find that page 59, lordship, of the advertisement.
69.
59. It's
Yes.
the advertisement 2012-2025.
Yes.
Column E. Maximum and minimum and maximum age limit. Maximum 18 years, minimum 18 years and maximum age shall be 26 years for unreserved candidate as on 31/12/2025 version. And thereafter, lordship, the earlier, lordship, advertisement, lordship, since we so far as apprenticeships are concerned, lordship, 2 clauses has been incorporated.
How can this court exercise that jurisdiction to incorporate certain clauses in the advertisement?
Because under the Apprenticeship Act, it is there.
It is required.
Yes, lordship. In fact, the refinery has already, in the earlier advertisement, lordship, that they have incorporated.
Show me.
Now they have been.
As per the Appendix Act, where is it?
Act and the
Where is it required? No, not the advertisement. As per law, it is required.
as per law, lordship, there is a judgment, lordship, and the guideline has been even incorporated by the Supreme Court, lordship.
By the?
Supreme Court, lordship.
Show me.
So this is downloaded from India.
In the latter part, Lordship, there is a guidelines.
Where is it?
The last portion.
No, there is not a law for the purpose of this.
Yes, otherwise also under the scheme of the Apprenticeship Act, Lordship.
You are an apprentice.
I am a friend.
So you say that you are entitled for age relaxation.
Yes, relaxation. 2 years, the period which I have, Lordship, under apprenticeship.
Where is it? Where is the law? Unless you don't have a law, you don't have a conceivable right to enforce.
Yes. Under the particular judgment, Lordship, under discussing the various provisions of the Apprenticeship Act, Lordship, they have the core principles, Lordship, that has been incorporated. Let's say.
No. Unless you show me a proper proposition of law, this court cannot incorporate, this court cannot, sitting in judicial review, ask them to incorporate this. Your last date is when?
9.
Okay. We'll have it tomorrow. Have a look at it. If you can find out, otherwise case for dismissal.
Lordship, can it be first Friday? Tomorrow, first Friday.
Why? 9th is set Friday. Why?
Tomorrow. If possible.
Tomorrow we'll take it up as motion. But find it. Otherwise today I am not going to issue notice. I
Yes.
would have dismissed it. They don't have a standing council of the Indian Oil Corporation?
No.
Let's see.
Yes.
Matter details to. For one side.
Here in your lordship, the petitioner, he was, in the detailed medical examination, he was found only fungal infection over shoulder. And subsequently, he appeared before the review medical board, and the review medical board finding your official find 47 years.
Same order that which I passed yesterday.
Yes.
He passed the same order. Dispose it off. Within 7 days, he'll submit a representation, he'll consider with this medical document.
Lodge.
Huh?
Yes.
I can't do anything else.
Yes.
Because as per them, you are unfit in view of the fungal infection.
Yes.
Now, you have taken some time from here, the patient has no lesion at present and his dermatology fit for clinical point of view. This is given by the registered department of here. You look into it. এই কালি এটা ডিসপোজ অফ কৰিছো AM খানৰ
WPC 7242
তাত খালি এইটো দি দিব
23.
এইটো that this court cannot not a fit case for entertaining, however, liberty within 7 days to submit.
Outcome maybe, your lordship, maybe directed to the respondent to communicate the outcome.
It will be communicated.
Where
Otherwise, they will not communicate it. Your
they
lordship.
will consider. I can't give you.
I just want to pray, your lordship, to give a time frame, your lordship.
They'll do it because the moment, because they are also in urgency.
Recruitment process is going on. It will take time. That's why.
They will, you submit your representation, same order.
16. Punished Ravan.
That's not copy has been furnished to me.
No, mistakenly, my lord,
What is your case?
Our case is regarding, my lord, non-payment of an amount of rupees 21,77,321 rupees and 22 cents, which lordship petitioner was invested lordship during the time when he was serving as a secretary of the restaurant number 5 society. Lordship, and the said facts was already lordship mentioned in the yearly audit report by the departmental auditor. And upon application by the petitioner lordship, the register of the cooperative society is also directed lordship, the society lordship to pay my dues lordship. Page 47 is the order which was passed by the register lordship. After considering all aspects lordship, page 47 is the order.
This was done on 24. Then
Page 47, what is the order?
why you are asking the register to release it?
My lord, what was happened, my lord, after leave?
Now what are you, why are you aggrieved?
This order was passed under section 92 of the cooperative society that by the registrar. So thereafter, lordship, that order was not complied lordship by the respondent number 5 society lordship. Then I make several applications lordship before the register, but that was not considered because the section 93 lordship, there is a specific provision lordship. When such order was not complied lordship, then the register may act as a civil court lordship for attachment of the property of the society. There is a provision lordship in the section 93, but the register lordship, although the order was passed in the year 2024, now repeatedly lordship requesting the board of director of the society lordship for payment, but no initiative from the society, respondent number 5 for payment of that amount.
So you are against that cooperative society conduct? You are against which order? I mean, which provision you are referring to?
In the meantime, lordship, the order, page 56, there is an order lordship which was passed by an additional registrar. Who is lordship inferior officer than the registrar? He passed an order lordship, page 50.
Which section you are referring to?
Page,
When there is an order under 92,
92.
reference of a dispute,
Yes, lord.
then settlement is made under 93.
93 subsection 3 lord.
Hmm.
Where the registrar is satisfied that a party to any reference made to him under section 92 with intent to defeat or delay the execution of any decision that may be passed thereon is about to dispose of the whole or any part of his property, or is about to remove the whole or any part of his property.
Notice
from the
making it returnable on. এখন বেলেগ আহিলে নেকি calendar? এইমাত্র বেলেগ এখন ক্যালেন্ডার লগাই দিলে নি আগৰ ক্যালেন্ডারখন করছে হ্যাঁ কোনকে বেলেগ লগালে issue notice making it returnable on 9th of March 2026. Mr. So-and-so accepts notice on behalf of the respondent numbers 1 to 4.
1, 2, 3, 4 months, yes.
As regards the extra copies of the petition be served upon him by tomorrow. As regards the respondent number 5, steps be taken by way of speed post by tomorrow. In addition to that, liberty given to the petitioner to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. First off, it is the case of the petitioner that the petitioners who were petitioner who was a secretary of the respondent number 5 society is entitled to an amount of rupees 21,77,321.22 paisa from the respondent number 5. It is under such circumstances the petitioner had approached the register of cooperative society for appropriate directions. First of the register of cooperative society by an order dated 12/3/2024 directed the respondent number 5 to release the outstanding dues of the petitioner within a period of 1 month. So it is the further case of the petitioner that in spite of the said direction, nothing has been done. And as such, the petitioner had represented the register of cooperative society on various occasions. So the grievance of the petitioner herein is that instead of exercising the powers under section 93(3) of the Assam Cooperative Societies Act 2007, the register of cooperative society, the respondent authorities have only been requesting the respondent number 5 to make payment. And it is under such circumstances the petitioner has approached this court. The respondents herein are directed to bring on record their stand by filing the affidavits on or before 27th of February 2026. Liberty given to the petitioner to file any reply on or before 6th of March 2026. Pendency of the instant writ petition, however, shall not bar the respondent authorities to take further steps in accordance with the provisions of the Assam Cooperative Societies Act 2024 for the purpose of as against the respondent number 5.
Hearing that the Ellis deformity was effective distance which year also. It was found 6 by 9 both times. Whenever the petitioner was examined at Guwahati Medical College at the time, he was not found that.
Same order.
At this stage, your lordship, I am paying for obtaining instruction, your lordship, how the petitioner has been rejected, your lordship.
Why so?
Because your lordship will
You are unfit for defective distant vision,
Distant vision,
injury, scar marks on left ear, little finger,
No.
then gynecomastia or whatever may be. All these things are there. Final opinion, unfit on account of defective distant vision.
take by.
Then,
But page 49, your lordship, that is. And here.
what is this? Color vision,
Nothing, your lordship, 6 by 6 is given, and 6 by 6 is the normal range here.
so therefore, can I decide?
Only praying, your lordship, at this stage, if your lordship will ask for production of extraction, how he has been rejected.
Disposed, same directions. Yeah, one hour that police. Same direction, 7 days representation, they will tell. Yes, Mr. Biswas.
The matter relates to the complaint appointment. The petitioner case was rejected by the SLC on the ground, serial number 90, page number 63, kindly, service matter.
Page number?
Page 63. Page number 63 and serial number 90, 5% quota is already filled up. Thereafter, I have filed this petition matter, that is pending in the High Court matter. In the meantime, my lord, new notification has come up. That is in page number 105, my lord, kindly.
Yes.
30th August, wherein some condition has been given that the petition pending those who were earlier shall not be given as the effect. Then, my lord, there was a judgment of the Honorable High Court by my Lord Justice Shyam, that is, my lord, Abdul Kalam Azad and the state of Assam. That was where the Honorable Court has directed to consider all these things, but that was under challenge by the government. So, to my information, that appeal has been disposed of without fully not interfered in the matter. But I could not obtain the copy, my lord.
So what do you want?
My lord, now that notice was issued, my lord, regarding this, we have challenged this order.
Mr. Biswas, this is a case for dismissal, no notice. Person died when? 2016. You have been very well doing out there. You will be it will come within the ambit of the 216/2015 notice office memorandum. Then 2 years down the line, the period has to be considered. You have to file within a period of 1 year. Then you filed it. 2 years down the line, you have to be considered. You haven't been considered, there was no vacancy. Unless you show that on the date on which you filed the application 2 years, there was a vacancy and you have not been considered, that's a different thing. Otherwise, it's a case for dismissal.
Pending in the office of the SLC.
So
and
what?
after DLC.
So,
SLC
no way.
for long period, my lord. They have not.
Long period, no
pending.
period. You see, I think it's high time. You see, this is not a case of compassionate appointment. Compassionate appointment has to be done within a period of 6 months. Otherwise, it is no case.
Now I have
Therefore,
challenged
the
this notification.
principle number 9 and 10 of the office memorandum dated 1/6/2015 has to be applied. That case.
I have challenged the notification of 30th of August 2025.
What is that?
Now new condition has been given by the government, by executive order has been given.
Forget about that. You don't come within that. You'll come within the 1/6/2015. If you don't have a case, then forget about 31/8/2025. Your thing you have to show. Dekho, heard Mr. S.C. Biswas, the learned counsel appearing on আজি এটা judgment এটা দিছিলো খালি ডেট কিটা বদলাই dismiss কৰি দিব Your petitioner in person?
Yes, your lordship.
Why you are wearing a gown? Gown.
What is the irregularity of
Down.
selection procedure?
Brown. You're brown.
Yes.
Lordship may oblige to allow for additional affidavit
Why?
because the matter is being the petitioner in person, the matter was filed at the first part of December. E-filing is done on 3rd day of December 2025. But eventually the matter is listed lately due to winter break as well as.
What do you want here?
So instantly the appointing authorities declared the final result few days ago, 6 days ago, 1st day of January 2026. So Lordship may oblige to allow the petitioner to file an additional affidavit for the interest of justice.
Appointment of chairperson and member of the Child Welfare Committee
Yes.
and Social Workers of Juvenile Justice Board of Assam. So you applied there.
Yes.
Then what happened?
Being a candidate for the member of CWC.
Okay, then what happened?
Yes.
What happened?
So this is occurred
Where is the select list?
without following the ratio of 1/3. As per the selection procedure,
What is the one-third
One
business?
third ratio should be followed by the authority of appointing authority.
Where is the one-third?
One third.
Yes. Application complete in all respect received in respect to it shall be scrutinized in a manner. A panel of shortlisted candidates shall be prepared in the ratio of 1:3. What is one? Why 1:3 means?
One third ratio
Means?
per post, three candidate. must-
Okay, 1/3. Okay.
Must have to,
Thereafter, it shall be placed before the state level committee constituted under so and so. The state level reserves the right to reject any application. So you were brought within the ambit of 1:3, 1:3.
yes,
Then? What is your grievance?
my candidate sir is not calculated regarding the one third ratio.
Okay, you must have applied against a particular post.
Yes,
Which one?
member of the CWC.
That I know. There are many posts.
Same irregularities occurs.
Member, there are many in which,
In Rajkot district also.
in which district? Mr. Petitioner in person, let me tell you, I don't go as per these paper reports. These paper reports cannot be trusted. The division bench can only trust the paper reports on as a PIL, not for me. So my question is, in which place did you ask as a member of the CWC? Kamrup Metro. So there was no 1:3 being done.
One is to
Kamrup
three ratio is
Metro,
not
it will
used
be-
by the authority.
Kamrup Metro will be 3 members.
Yes,
3 members, 1 will be female. So amongst male, only 1 post is, 2 post is left. So against that 2:6, it will be 2:6. So you are not there amongst the 6.
yes. Yes,
Yes, what do you say?
Let him file an additional affidavit.
Who? I find him a very good case. I'm going to allow his petition. Now tell me, what do you have to say?
Let him allow.
Allow. Chalo. We set aside this point. Directing the respondents to press a fresh select list. Where is the select list prepared?
the case is not received till now.
Huh?
Recent incidentally, they announced the select list, 1st January 2026, recently.
Have they announced the select list?
Yes.
Where is that?
Not collected in this. Right.
So why are you asking for preparation of a fresh select list?
Not asking for preparation of press selection list.
Isn't it your prayer at page number 6?
I'm asking for only file an additional affidavit regarding the delay.
Delay in filing the writ petition.
Yes.
Forget about that. I'm asking you. You are asking as a writ in the nature of certiorari, it should not be issued directing the respondents to prepare a fresh selection list as per the advertisement dated 6/6/2025. Now, as to whether there is a fresh select list prepared,
Lordship may oblige for the procedure.
huh?
Lordship may oblige.
What should I do? The only thing advice I can do is catch hold of an advocate instead of doing your matter by yourself. Okay? You ask Mr. Rupjit Dey. Mr. Dey, kindly help you. Okay, list the matter on so and so. This report has appointed have requested Mr. R. Dey, the learned counsel, so as to assist the court in the matter, taking into account that the petitioner in person have not been able to apprise this court. List this matter again on 21st of January 2026 for motion. You just find out and tell me what it is. And you also come prepared, madam. Don't come out here like this. Yes, Mr. Das.
This is a case of dismissal, madam.
Ah.
Arising out of an FIR, here our lordship will find at page 29. But he is a madam constable. Assam Police, madam. FIR is at page 29.
You went to jail,
Madam, yes, madam.
then convicted.
Then, no, madam, the case is pending, madam. That, but the DP has been proceeded and I have been dismissed.
Okay, then
Then, madam, now, madam,
why you are not filing an appeal?
we have filed appeal, madam.
Where is the appeal?
Appeal, madam, the appeal order is at, madam. Page 66, madam. Is the order passed in the appeal, madam? That authority has upheld the dismissal, madam.
Okay. Sure. Okay, we issue notice.
Madam, one thing possible note, madam. The inquiry report, that has also not been served to me, madam, in this case. And madam, I filed an RTI, madam, application. They said that these are exempted.
Mr. Das, without you saying anything, I have been very generous enough to issue a notice. I hope you are not asking for the interim prayer. That is, interim prayer is only to show the petitioner that there is I can make a prayer.
Thing is that
You also know.
That-
And no, the question, the Mr. Das, it doesn't arise about the interim prayer. A person who has been terminated, this by way of an interim order, I will allow you to be continuing in service.
the law of parity is there. Same affair, same accused person. One has been, madam, reduced the increments and I have been dismissed, madam. That is my case, madam.
So then can I allow the petition on the first day? Can I? Very good. But only thing you can say that as it is a very illegal dismissal, the matter needs an early disposal. Yes. Or issue notice making it returnable on 24th of March 2026. Mr. T.C. Sutia, the learned additional senior government advocate, accepts notice on behalf of the respondent numbers
All the respondent.
1 to 7. Extra copies of the writ petition be served upon him by tomorrow. The petitioner herein is aggrieved by the order of dismissal from service
Page 61.
dated 3/7/2023, as well as the subsequent dismissal of the appeal filed thereagainst by an order dated 29/2/2024. Full stop. Mr. S.P. Das, the learned counsel appearing on behalf of the petitioner, submits that the dismissal of the petitioner is completely contrary to the principles of natural justice in as much as the petitioner was not even provided the inquiry report, and as such, the petitioner has been seriously prejudiced. It is also the submission of the learned counsel appearing on behalf of the petitioner that the punishment so meted out upon the petitioner was disproportionate in as much as on a similarly charged in as much as the respondents have reduced certain reduced the salary, no?
No, yes, madam. Two
Re-
increments.
Reduced 2 increments in respect to another similarly situated
FIR name accused, madam. FIR name accused.
another similarly situated FIR named
Sorry, madam. His name is in the source, not in the.
in respect to a similarly situated person, employee, whereas in respect to the petitioner, the respondents have dismissed from his service. Full stop. Taking into account the said aspect, the learned counsel appearing on behalf of the petitioner submits that since 2023, the petitioner is no longer in service, and as such, the matter requires an urgent disposal. This court have also given an anxious consideration to the materials on record and is of the opinion that the instant petition requires an urgent disposal. Accordingly, the respondents herein are directed to bring on record the stand by filing the affidavits on or before 13th of March 2026. Petitioner given the liberty to file reply on or before 23/2026. Full stop. The respondents shall also produce the records of the departmental proceedings as well as the appeal proceedings on the next date so fixed. Full stop. An attempt shall be made to dispose of the writ petition on the next date.
Plus one.
Yes, what is this?
May I please, Lordship? Lordship, this case is pertaining to a short issue, my lord. Pertaining to a short, I filed an application under section 75 of 35 copies of documents relating to my compassionate appointment. But my lord, the application is still pending with the respondent number 2. My lord, the application is at page number 14, my lord.
You filed an application for?
Certified copies of documents pertaining to my compassionate appointment application, man.
Which application?
Page number 14, my lord.
1-4.
Yes.
Then?
My lord, this application is still pending with the respondent, my lord. I tried to file a legal notice to the respondent at page number, my lord, 23. At page number 23, I tried to file a legal notice, but that was also not answered, my lord. Then to know the status of the of my application under section 75, my lord, my lord, filed an RTI to know the status, my lord. The RTI, my lord, will find it.
You filed an RTI?
Yes, my lord.
Where is that?
Page number 28. 28. My lord, the respondent number, respondents, respondent authority, my lord, dismissed my application saying that my application does not warrant any, my lord, any action, my lord.
Where?
The first point, my lord, page number 20.
Page?
Page number 28, my lord, B1, annexure B1.
Your application dated so and so under the Right to Information Act. Reference to application under the no action is warranted as section pertains to judicial record that forms part of the judicial. However, with reference to your application for compassionate appointment under process, any development in the matter would be communicated in due course. Then what the case do you have?
My lord, this stand is completely violative to the judgments of the AP court and my lord, also the division bench of this court, my lord.
What is that?
My lord, in the case of Malti Biswas, my lord, this honorable court has stated that if an application is filed under section 70, formally section 76, my lord, now in BSA 75, if the application is filed, my lord, the copy has to be provided to the applicant, my lord, on demand if he has the right to inspect, my lord.
Is it pertaining to some judicial records?
My lord,
75 pertains to what?
well, certified copy.
You have applied under the for compassionate appointment, isn't it? You have applied for compassionate appointment. Now, what are you asking for? What documents you are asking for?
My lord, the respondent.
What documents are you asking for?
My lord, there was a copy. There was an order by the head office asking me to file a fresh application for compassionate appointment, as my application was for was in pre-revised format, my lord. But the respondent has not given me nor the copy of the my lord order, or nor gave me the copy of the scheme, my lord. The revised scheme also was not provided to me, my lord. Nor the application was also not provided to me, my lord. So how will I, my lord, comply without the copy of the order, my lord? I tried to file a representation before the respondent, my lord.
Now, what do you want actually? Means you want a compassionate appointment job.
But that is a different, my lord. In this petition, I am seeking the certified copies of the document, my lord, that I requested in my application.
How many documents you are asking for? At page 16? 36 documents. 36 documents. What is the basis of these documents?
My lord,
Are these documents in existence?
yes, my lord, as per the respondent, as per the order of the respondent, my lord, they have informed me that there is an order by the head office, my lord, that I have to file an application.
For?
Fresh application, my lord.
For?
And in the revised format, my lord. But
So why you are not filing it?
my lord, the respondent have not provided me the revised scheme, my lord. My lord, kindly come at page number, my lord.
So this is not for compassionate appointment. Oh. What is this
No,
case?
this is nothing but wastage of valuable judicial time. My lord. Section 675, Lordship is aware, my lord. These are for public documents, my lord. Section 74 and 75, my lord, makes the situation clear. My lord. These are bank records, a scheme of a bank. And at page 53, which is annexure F3, my lord, Lordship will find. This is the final communication between the parties.
Page 37?
53, my lords. Because what happened was that initially he applied under this section 75. We said we can't give you under section 75 because this is not
Please
applicable.
confirm whether ECG Jailer, which stands for Employment on Compassionate Grounds, exists under the human rights. The mention is in the reply to the EI appears to be a misinterpretation. I think this is a bench 4 matter. Or we issue notice making it returnable after 2 years. Then you will.
My lord,
He
in the
has
case
already
of-
filed
my
a
lord,
separate
this-
petition which is pending. Man.
Huh?
He has already filed a separate petition for the compassion
Well, that
appointment.
is a
which-
different,
which is
different matter, my lord. I require this document, my lord. Those are very important.
Because in view of page 53, let me, my lord, in view of page 53, he should either, if he is dissatisfied with page 53, he has to file a statutory appeal under section 19 of the RTI Act. He cannot come to the writ court asking for a mandamus. No. That liberty may be given to him. If he is dissatisfied, he can go and file a first appeal or further to the CIC.
The RTI pertains to, my lord, only the status of the application, my lord, not, I am requesting the documents in the section 75 application. And my lord, for
Hey, BSA consult.
my lord, also in the case of Omaram, my lord, the Honorable Rajasthan High Court also, my lord, permitted
Go to
the-
Rajasthan High Court. BSA, Bharatiya Sakshya Adhyan. 75 will be earlier 77.
Earlier 76, my lord, 76 Indian Evidence, IEA.
Indian Evidence Act, which will be?
Malad, this will be Malad, regarding the certified copies of public documents, which are in the custody of public documents, Malad, or judicial records or executive authorities.
No, 77 will be what?
The 75 and 74 have to be read together.
No, 70 he is asking for under 70?
75.
35 are public. These are not public documents. Chalo, we dismiss your case.
My lord, these documents are, my lord, the records of Nationalized Bank, my lord.
I need you to trouble the division bench. It would be the most funny thing which may happen. You go there. No, you should trouble the division bench. Let me dismiss your case.
My lord.
Heard the Mr. S. Kumar, the petitioner in person. No, nothing. Division bench.
My lord.
And Mr. A. Ganguly, the learned standing counsel of the PNB branch.
Reply in RTI, my lord, in my lord, may, my lord.
Enough.
My lord, may kindly.
The repetition has been filed by the petitioner
My lord, may kindly see this, my lord.
seeking a direction upon the respondents to provide certified copies of all documents requested by the petitioner in the application dated 19/8/2025. The said application dated 19/8/2025 is annexure A1 to the writ petition. The information what he has sought, what the petitioner in person have sought for is at annexure 1 to the said application dated 19/8/2025. The information and the documents so mentioned out here in annexure 1 under no circumstances comes within the ambit of, within the definition of public documents as defined in where is the public documents definition?
Section 74 minutes.
As defined in section 74 of the Bharatiya Sakshya Adhiniyam 2023. Full stop. It is further seen that in pursuance to the said communication, a reply was also sent to the petitioner on 27/10/2025, informing that these documents do not, that no action, that the applications filed on 19/8/2025, no action is warranted, as section 75 of the BSA Act 2023 pertains to judicial records that forms part of the judicial proceeding before any court. Full stop. Be it as it may, it is pertinent to mention that as the documents which have been sought for at Annexure 1 to the application dated 19/8/2025 do not fall within the ambit of public documents as defined in section 74 of the BSA Act 2023. The very application so filed by the petitioner on 19/8/2025 is totally misconceived. Next, this court also takes note of from the materials on record that the petitioner had approached the respondents again under the Right to Information Act 2005, and in pursuance thereto, the petitioner had been provided various replies. Full stop. It is full stop. This court further takes note of that section 19 of the Right to Information Act 2005 categorically mentions that if a person is aggrieved by the information being not provided, an appeal lies. Full stop. The petitioner, instead of filing an appeal, has approached this court. This court therefore does not find this to be a fit case for being entertained. Accordingly, the petition stands dismissed. Chalo.
Deep, deep.
Yes, what is this?
Yes, sir. The petitioner was recommended by the state level selection committee for completion and appointment on 21/2/2021, madam.
Where?
You will find at page 27 annex 8. Then
20.
the department has contemplated for appointment on completion of ground, but mere exchange of some intra-department communication, nothing has been done. Lordship will find that page 27 annex 8. This is the minutes of the meeting, madam. Then your Lordship will find it
31.
Page 39 annex 9, madam. From annex 9 to annex 12, all are columns.
Page?
Page 39. Every year they have exchanged that communication requiring to fill up the forms in prescribed format, my lord. Nothing else in this.
Well, what do you want?
My lord, because that it was recommended in the year 2021, man. Now they are delaying the matter. It will frustrate the policy of the completion of the problem.
Also, can you see page 31? His recommendation by the SLC.
So what are you going to do? Grade 4 after
Grade-
having a BA?
Grade 4.
That?
Page 31.
Your father died in the year 2015. What case you have? No case for a compassionate appointment.
Well, it was duly considered by the district level committee as well as the state level committee. Now your lordship will find that page 42 million, annex 11 million.
They may have taken a policy now to not
No,
to
they
appoint
have
anybody.
rejected. Well, kindly see page 42 and annex 11, page 42 million.
Yes.
This is the communication of 24/6
Yeah, affidavit
24
of the three
by the
incumbents, so and so, so and so,
Government
along with
of
comments
Assam,
will be
Employment and
authenticated by all
Department,
documents and the
the Director of Employment Department. In writing with reference to the subject cited above, I am directed to request to resubmit the up-to-date proposal for three incumbents, Sri Navakanta Das, Parthapatiam Saitya.
So they are providing this, na?
Yes, my lord.
Okay.
They are contemplating but delaying on. That is my grievance, my lord.
They are delaying.
They are delaying.
The page 31, Lordship, kindly see.
Issue notice making it returnable on 25th of March 2026. Mr. T.C. Sutia accepts notice on behalf of
2, 2, 3.
one also?
No, 2, 3 and.
No, why not one?
Skill employment, one spending council is there, SP Das.
No.
I can accept it.
Okay, 1,
1,
2,
2, 3,
3,
5 and 6.
5 and 6. 7 also?
7, Manot.
Same.
Yes, Manot. Principal.
7. Mr. P. Naik accepts notice on behalf of the respondent number 4. Extra copies of the writ petition be furnished to them by tomorrow. It is a case of the petitioner that the petitioner's father expired in the year 2015. And thereupon, immediately the petitioner applied for being appointed on compassionate grounds. First of all, it is further seen that the respondent authorities, more particularly the district level committee as well as the state level committee, including the skill development, the Assam skill, employment and entrepreneurship department have been forwarding application, have forwarded the recommendations and proposals for the appointment of the petitioner. But the respondent authorities, for reasons best known, have delayed in the appointment of the petitioner, and it is under such circumstances the petitioner is before this court. Taking into account the above, the respondents herein are directed to file the affidavit on or before 16th of March 2026. Next date ki main diso?
18th of March.
Huh? 16th of March 2023. 26, liberty given to the petitioner to file reply by 23rd of March 2026. What is this?
Petitioner has come against the rejection of his candidature on the basis of certificate he has produced before the authorities, claiming OBC and NCL also. Lordship, as per clause 6.5 at page 27, 6.5 of the 6.5 at page 27, Lordship.
Crucial date for claim of SC/ST status or any other benefit for fees concession year will be the closing date for receipt of online application form from 14/10/2024. Then what do you want?
Lordship, my certificate that was issued by the Office of the District Commissioner, which was issued beyond the crucial date, Lordship. But there is a categorical statement in that certificate. If your Lordship may kindly come to page 32, Lordship, for a moment. It's issued by the Additional District Commissioner to Presiding Officer, BSF Padgaon. Lordship, here at serial number 14, my name appears, Lordship, Jagannath Ray. The candidates are presently being rejected because of no production of OBC and NCL certificates prior to the date of filing of application, that is 4/9/2024. The candidate has intimated that the examiner of the recruiting departments are looking for NCL certificates prior to the last date of application, that is 14/10/2024. In this regard, it may be mentioned here that the candidates have applied for NCL candidate certificates recently, and as such, online NCL certificates generated. It is to reiterate that the existing system cannot generate backdated NCL NCL OBC certificate. Lordship, this is very important, the last paragraph. As such, considering the fact that the appearing candidates genuinely belong to OBC community since birth and certified as belonging to NCL category as per financial report of the year 2024-25. The candidates may be allowed to appear. Now, Lordship, that crucial date very much falls within the financial year, Lordship, 2024 to 25. As such, I may be allowed to participate.
How? You got your certificate, NCL certificate when?
Well, sir.
12/7/2025. Then,
But there is a,
when did you apply?
I applied letter that is admitted fact, Lordship.
Then, didn't you know about this thing? That it was required to be done?
Yes.
10 pass candidate.
5/9/2024. Then, why did you apply late?
There are 10 pass candidates, Lordship.
I would have understood that if you have applied earlier, it's a different thing. Oh, bad case.
There are clear judgment, there are lots of problems.
You applied when?
I applied later, Lordship. Not have anything.
You had a caste certificate earlier,
Yes, Lordship, I had.
but you wanted an NCL.
NCL. NCL comes in a financial year, Lordship. It is valid for 1 year. This is only to reiterate my status that I belong to NCL, Lordship. It has to be issued by the district commissioner.
So, what is the last date for submission?
14/10/2020.
We are in 2026.
We are in 2026.
You did not apply.
Recruitment is still going on. Lordship. Recruitment process is still going
No,
on.
no, have you applied?
Lordship, I have applied, but they said that they cannot give a caste certificate, NCL certificate in backdated certificate, Lordship. Since
No,
it
no,
is a-
no, 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 I'm not answering. Did you apply in pursuance to 5/9/2024? You could not have applied
I could have applied. Maybe the candidate could have applied, Lordship.
as a, but not a NCL. Didn't it? You could have applied as OBC. Did you apply as a OBC?
It might have applied, Lordship. I don't have that document, Lordship.
Then, what is the last date for application?
The last date is 14/10/2020.
No, 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 it can't be. Yes, tell me, what is it?
14/10/24 is the
Last date and time for application is 14/10.
Yes.
Now, I don't understand. 14/10 is the application date. Okay. Kindly come to page 28. You require the educational qualification as on 1/1/2025. How does it make sense? Huh? Does it make sense? I don't understand that very aspect.
Before the cutoff date, that is 1/1/25.
You want the educational qualification as on 1/1/2025,
Lordship.
but your last date for submission is 14/10.
They have
Last
issued
date
the
of submission,
advertisement
it
on
should be
5/9.
prior to 14/10/24. That online application form, that is 14/10/24.
So you have not applied till now. You have not applied.
I applied after the.
You can't apply now.
I cannot apply now, Lordship.
So matter over. What is there? I should
Yes.
therefore extend this period.
No.
This is what you want. My therefore question is, did you apply?
He applied as a OBC candidate.
Then OBC candidate you will, but OBC candidate won't get it.
Yes, you won't get.
Won't
NCL
get.
will only-
Then now you want that NL, that
NCL.
non-NCL certificate should be accepted.
Yes.
What do you want?
Yes. I want that, I'm praying that on the basis of the certificate issued by the additional district commissioner, that I belong to OBC NCL for the financial year of 2024 to 25. And an NCL certificate has to be certified by the district commissioner lordship. It has been certified by the issuing authority.
He applied as a OBC candidate, and for the year, he is not NCL. That certificate has to be given, which will be
Whether I
private.
am NCL or not, that has been certified by the additional district commissioner. Although it is admittedly beyond the crucial date.
To the post of rejected. Disqualified in biometric verification. Original 10 stated in subordinate is not produced. Original certificate not produced, not in prescribed form. Original any other discrimination in this EOB in 8399 in the age on 1/1/2025 is Iman. OBC non-criminal engineer is on 1410 not produced, due to which you are overage and not eligible to get OBC relax. Okay, so the reason for rejection is this.
Yes.
That DOB is 8399 and the age on 1/1/2025 is 25 years.
25 years.
OBC non-criminal certificate as on 1410 was not produced, due to which you are not entitled to overage.
Yes.
Okay.
The last one, we have.
So what is wrong with this order?
Otherwise, nothing wrong.
Then why should I exercise?
Only thing is that lordship, whether my NCL status goes just because it is produced beyond the crucial date. Lordship, there is a judgment, if I may be allowed to.
Your NCL status does not go. Your NCL status remains.
But
But the fact that that document should be a part of the TIA is also a matter. So you have not submitted, means in fact, what you are asking is that this court should permit you now to accept that certificate, that they should accept that certificate beyond the period. Isn't it?
he applied on the day of verification. Lordship. But the district, office of the district commissioner said that we cannot issue a backdated certificate as on 14/10/2024.
How can they give you a backdated if you apply later on? Hello, I have to rise today. Other motion matters, I'll take it up tomorrow. And this one, we'll dismiss it tomorrow in the first thing in the morning.
9th, other matters are also pending before this honorable.
So 9th,
Maybe taken
many
up on
more
9th.
matters are there.
Let it get dismissed together.
Huh?
Let it be fixed on 9th, Lordship. At least I'll have a chance.
Okay, 9th, I'll dismiss this case. 9th is the case for dismissal. Other matters we will, other motion matters, any urgency is there? We took 9th, list the matter on 9th. Motion? No, all motions tomorrow. All motions will be taken up tomorrow.
Lordship, may I please, Lordship? May I please, Lordship?
Tinta punon muthibo ni.
May I please, Lordship? Item number
There is a
37, Lordship.
printed reference, I suppose. Huh?
Item number 37, Lordship. After verification, Lordship, and fixed the date, Lordship.
Motion,
Lordship, interlocutory application, stay vacating petition, Lordship. Stay vacating petition, Lordship.
stay vacating.
Yes, Lordship.
Who has filed?
Yeah,
Stay vacating, you have filed.
yes, Lordship.
Ex parte.
No, Lordship, expert.
37 is you have taken an ex parte in interim order.
Yes.
Stay.
Yes, Lord.
And if it is vacated, if I have it after if I have it after vacation, wouldn't 226(3) apply?
Lordship,
Wouldn't 226(3) apply?
Lordship, we have already filed our objection, Lordship.
No, Mr.
Yes,
You see, you have taken an ex parte order
yes, Lord.
against him.
Yes,
So he files an application under 226(3) for vacating. Now, the moment the matter comes up before me,
Yes.
I take it today, just for example, I extend it after 14 days. But I have to also extend the stay order also.
Yes, sir.
Because if I don't extend it, otherwise 226(3), by
Yes,
operation of 3, it will get vacated.
Yes, Lord.
When do you want?
View vacation.
After vacation, December?
No, no,
When?
Lordship, on 21, Lordship. 21 January, Lordship.
21, 28?
Lordship, 21 or 22, Lordship. On 28th, I will be.
Okay,
not available.
22. Okay, 22. List the matter again on 22. Full stop. This court, having heard the matter, have extended the interim order passed on so and so till the next date.
Of like